mama's in the living room watching Judge Judy. I'm in the kitchen eating leftover sushi, and she goes, oh, girl, you gotta hear this one. A man was arrested for running a theme park, and when they said, where's your license? He said, my dog ate it. Oh, you can't make this shit up. Sometimes I wonder if life's just one big cosmic joke. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout, girl, you gotta hear this one. Mama loves to laugh at how absurd life is, says it's all a comedy and I'm her audience. And I love the way she makes fun of the world. She said, you'll never guess who's with their girlfriend. It was a man who didn't get us out of the bed. He said, I've been through hell and now I need some help. You just can't make this shit up. You just can't make this shit up. Sometimes I wonder if life's just one big cosmic joke. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout, girl, you gotta hear this one.
Hey everybody, welcome to the first real stream with content using Restream. So please forgive me if there's some hiccups along the way. I'm learning new things. My uneducated, obese self has to figure out new shit from time to time. We are doing part 3 of the Tyler Robinson evidentiary hearing from last week. Well, a week and a half ago now. It was all done in one big session. However, we don't have time to sit through with commentary in a 4-hour hearing. So this allows us to break it up, talk over it, have some things to say because we have opinions. I have lots of opinions. And here joining me with his opinions is Flashfan.
Hey,
how are you, my friend?
Hey, I'm good. Thanks for having me. Glad to be here. These people made me do some research about the law, and I don't usually research. I usually just research cases.
These people make me think things that I shouldn't think. However, before we get started, I have to do a little unboxing for y'all because I got a package in the mail.
Ooh.
And I got a package in the mail and I left the paper out there. Snipe Hunter. Don't be so hard on yourself. You're borderline obese. Oh, yes. Somebody in one of their emails to me and my lawyer decided to call me obese, uneducated, psychopathic stalker. Like what?
Wow.
Yeah.
What people would go through.
But I got to be right back. I got to get the piece of paper that actually describes what this is. So while I am gone, would you like to educate people about what, if we finish this, what we will be doing either later today or tomorrow?
Yeah, sure. So, this is the Tyler Robinson hearing. The hearing, if you were here or if you want to hear, to recap, there was a motion filed to find the prosecution in contempt of court for violating the gag order. Apparently, the defense made statements. Can't remember off the top of my head what the statements they made, but the state felt they had to clarify it, which the rule 3.6, what they're arguing over, they had me doing research about the law, and Utah says that they can under limited circumstances, but, and they also did also a motion, we haven't got to that part yet, did a motion to exclude hearsay at the preliminary hearing. And there was a ruling today on that. Don't know what that is, but it's short. So if we get through this, it says we may do that either today or tomorrow.
All right. So what I have to do really quick is, so I got a package. It's 3 boxes.
Ooh.
However, it is the triquetra. 3 interlocking loops is held as a great significance in old Irish culture, representing the pillars of life and societal order, loyalty, truth, and societal justice. Then that knot sometimes is represented within a circle, and that circle signifies family or clan unity. And this was commissioned for me, for the little, and one for Mr. Squid, by a very special family member of community member. So this is going to be very interesting. This is the first time I've actually opened it up, but I just got the box in the mail this morning. So I'm very excited to put
Doing one of those unboxing ASMR, y'all.
I'm like, y'all.
Oh wow.
Y'all. I'm about to cry. Because, like, it was not only just sent to me, it was made for me. And it's like someone adopting me into their family, and it's just it's a thing, and it's got a chain with it. But there's one for me, there's one for the little, and then there's this one, which is, I'm assuming, is Mr. Squid's. He's not a jewelry person, however, he does have a jewelry box with some stuff in it. But this is the...
I guess everybody likes some bling, whether they man or woman.
So excuse my nails. I have CrossFit nails / tears. So yeah. So woohoo. Yep. So there's that. So I'm going to be, while we're working on this, putting mine on the chain and putting it on, because that's gorgeous. Gorgeous. So yeah. So thank you to and y'all can probably assume who sent that to me. The family of Jeff Grady. So it's I feel honored is the only word that I can come up with right now. That, like, yeah. Hey, Stacy. Hope everybody is doing well today. We are going to get straight into this now, and get into this hearing, because we are, we're over halfway through, but I swear, this lawyer, Timu Law School Hall of Fame.
And there's some motions that were filed in between this hearing and the ruling hearing that, they talk about it in the hearing for what the remedies they want if they're found in contempt. So
it's just some things you're just like, why? Like, I understand they have a client to defend. I really do. Everybody is entitled to a defense, whether I like that person or not. However, just some of the decisions that are being made are just...
And I was reflecting on, like, how we think, like, are we judging them too harshly about, like, saying, like, it's the delay tactic? But all the lawyers I'm watch Andrew Burkhardt, Josh Ritter, who runs the Courtroom Confidential YouTube channel. He did a interview with the news either yesterday or early this morning, where he said it just looked like they're saying it looks like a delay tactic. Even the lawyers out there saying this looks like a delay tactic.
Yeah, I'm sorry. Like, I understand that there are things about lawyering and positioning and gamesmanship that I don't understand because I did not go to law school and I am not a lawyer. However, we are 10 months past the date of this crime. 9 months. 9 months past the date of this crime. It's a crime. It's just alleged who did it. So we are 9 months past the date of the incident, and he has not pled yet.
Yeah.
Which is like, even as a non-lawyer who trial watches, and I don't watch every trial. I watch the ones I'm interested in. But like, even you just know that 9 months later and he still hasn't put in a plea.
And
something is weird.
According to Google, a grand jury indictment or a preliminary hearing usually occurs 30 days after initial arrest or initial appearance.
And I understand that some are delayed for reasons, but generally about 1 to 2 months, even with some paperwork delays.
Yeah.
9 months. That right there is a delay tactic. Like, you don't have to be a lawyer to see the writing on the wall.
It's 30 days for preliminary, and if they don't waive speedy trial, it's 60 to 90 days until they get to trial in most jurisdictions.
And Duncan, Idaho, thanks for being a member for 20 months. Did I tell y'all my daughter was born in April? Yes, you did. How is she doing? How is she doing?
Oh, cool.
Little baby Duncan Nut. Little baby Idaho. All right. So this is one of his attorneys right now. This is the attorney that talks with his hands.
Richard Novak.
Novak. And he talks not only with his hands, but not like doing a timeline. He's talking at you. I was
reading one of the comments, and some people out there, they just mess cruel. They like Slovak is talking. I'm like, come on, man. Did you really have to call that man Slovak?
And Duncan, Idaho, thanks for the $5 super chat. Daughter's on the verge of learning how to laugh. I think 2 of my 3 months of parental leave just ended. It was so hard to go back. Oh, I know. I can't even imagine. Like, I was so lucky to be able to stay home. However, I know that that's not the case for everybody, including Mr. Squid. So I can't imagine. Like, I have not been away from her for more than like 6 hours. I can't even imagine.
How you gonna deal with when she go to school?
It's gonna be a mix of like, thank goodness I have some time to myself, and come home, I miss you. So it's gonna be they could have just stated another baby preliminary hearing. Well stated. Oh yes, and Heidel, for the next couple of days, I have the link for a I always want to say Ko-fi, but it's a Buy Me a Coffee that Spawn of AJ set up for her mother, alternate juror. Her home was impacted by the recent outbreak of tornadoes, and she would never ask for help on her own because she is an independent, very lovely lady. However, we can all ask for help for her. Because it's one thing to be a grifter on the internet, but it's one thing to ask for help when your house is damaged by Mother Nature being a twat waffle.
And that just makes it all more genuine because she doesn't ask for help.
She doesn't ask for help. And she didn't ask for help this time.
Nope.
Carmen set it up for her. Yep. So Carmen set it up, and then I still don't know if she's actually told her mom that she actually did set it up.
She knows because she put it in Discord.
Okay. I forgot to ask Carmen if she actually knew that her mom, or she actually told her mom about it.
I'm sure she did. If I know Carmen from the brief conversation I had with her before, she knows. She told her, I'm sure.
Okay. I figured she did, but I wasn't sure. I never asked.
And she probably wouldn't care if she didn't tell her. She might ain't tell her. Carmen is a cool person. Both of them are cool. Both of them are awesome people.
Yeah, Carmen's my dude. All right. We're going to get this started now that we've got our 15 minutes of obligatory BS and we've lost 7 viewers because of my talking and
7.
not getting straight to the point. We'll get this started. I think Carmen got yelled at. That checks.
Everybody got yelled at in a fun way.
That checks. All right. We'll get this started.
This is an order enjoining, as I cited in the brief, so I'm not going to cite all those cases again, say that where the order is in the nature of an injunction, the court doesn't need to make a finding of intent. Every order is different. This is an order enjoining conduct. And so if somebody violates, knows of, and has the ability to comply with an order enjoining conduct, and the order is violated, there's no need to show intent. However, what I will argue to the court is whether or not the court is going to add that element of intentionality. I think the evidence is clear that the violation was intentional. Or it was so reckless, and I will use the legal phrase extreme recklessness, that there's a very fair inference of intentionality. And I don't.
There was a very reckless and intentionality, just like your intentionality of putting the fact that the bullet didn't match in your defense motion, even though that's not true.
Yeah, it seems like they cried. They're like, okay, we went to the media. We're going to try to tell them the outside of the story. But when the state goes and try to put it like, Your Honor, they talked to the media. They violated your order.
It's very few times that I am like, yep, the state is right. It's very few times that I am like, go F yourself, defense team.
Yeah.
But like, no,
I don't always agree with the state in this case. Just like they filed a motion to, they want to have recorded statements at the, I guess he had a roommate. I don't know much about the facts of this case, but apparently they recorded
he had
statements.
a roommate, and apparently they were dating.
Oh, and they gave a recorded statement. They like, well, we just want to admit the recorded statement at trial. We don't need his testimony. The defense wants to cross-examine him. I'm like, can't do that. They have a right to call and cross-examine witnesses.
Well, and here's the thing: the fact that they were reported as dating isn't a big deal in the fact that they were dating, except for it does matter as for the psychology of why he thought the way he thought.
Yeah.
Because when someone thinks you are evil because they think you are against the way they live, when in all actuality, just because you don't agree with something, if it doesn't impact you, generally speaking, you don't care. Like, like this is where you will see my lack of coordination and my neurological issues come into play, because I can't put that on by myself right now. But
Papa Grid is asking, what did I say? I don't know.
I don't know. I don't know.
I say a God of days that's probably not the greatest. No, I don't know.
I don't know. Flashfan's a lot more knowledgeable about the actual attorneys than I am, and I know more about the backstory of the case than he does.
This case is actually making me want to do research on law, and I did research about this trial publicity order that they're talking about.
Why haven't you gone to law school?
And I don't know. Because it costs money.
That's touche. Right. Good point. No arguments there. I'm gonna restart.
Everything in the publicity order the state is saying seems to check out, if my understanding of what I'm reading is correct.
Papa's Good's got to go back. He's always hungry. He's always hungry. All right, we're gonna restart this again.
Don't say this lightly, and this is one of those situations where lawyers and judicial officers sometimes cringe, but sometimes the cover-up is worse than the original conduct. I know we've all heard that before, and we all know what that means. But I find no credibility in Mr. Ballard's sworn testimony that he only intended to communicate with the media generally about bullet fragment analysis.
What about you talking to
He
the
used
media?
phrases like this bullet.
Exactly.
If he should get in trouble, you should too, because you went first.
They also wrote it in a motion. I can't even say it like somebody does. If you know, you know. If you don't know, I'm not saying. When they put it in a motion that they knew was going to be read, and basically misrepresented the facts in a motion where people assume that lawyers are telling the truth, and you expect the state not to push back on that? Like, devil's advocate here, regardless of whether I hated the state or not, you put something, they knew this was calculated. This was not an accidental statement. Everything that lawyers do is calculated. Everything. It's why I regret not ever trying to be a lawyer, because I also am calculated.
I would love to see you as a lawyer. I just
It would not go well.
be destroying people.
It would not go well.
It gets
It would not go well. You know how many times I would get sanctioned? Oh my goodness. Who might have a tapeworm? Squid may have a tapeworm. What? We're just gonna not. I don't know what that was about. So we're just gonna restart this, because I could stop Novak from talking every 5 seconds and push back on every freaking word he says, because it annoys me. But I'm gonna try to keep my mouth shut for at least 30 seconds to a minute at a time.
Yeah, because I'm sure you're gonna pause when he's gonna say the Roman, because this is going. Oh, I can't wait.
He's responding to misconceptions in the media about what the defense said in its filing. He's talking about the bullet fragment analysis in this case. And I have trouble accepting Mr. Ballard's explanation that he really never said anything about the bullet fragment analysis in this case, especially, I mean, the most clear example, frankly, is his statement in Exhibit 7, which is his statement on Fox and Friends. Because he talks about this bullet, the bullet. He's not talking in general terms. He's not talking in generic terms. He's not a ballistics expert, although in some of these exhibits you see that the journalists interviewed ballistics experts. Mr. Ballard is trying to influence public perception about examinations in this case. So are you
by stalling every 5 seconds?
And I think to say, oh, I'm not talking about this case, I'm only talking about ballistics generally, is
this gonna
belied
take
by
years to go to trial.
the context in which the statements were made, the motive that Mr. Ballard and Mr. Gray admit they had in engaging in extrajudicial statements, and the content.
I agree, Vicky.
Mr. Ballard also acknowledges that he made statements about future examinations and his expectations about what future FBI and ATF reports would say.
And this is why it's taking us 3 times to get through this, and not going through it and just watching it and making comments here and there, is because I have thoughts. And who would I be if I didn't share my thoughts with random people on the internet?
This case he has a lot of people divided from what I learned. The more I learned about the case, I'm like, "Ooh, this is going to be messy."
Yeah, Flashfan is hungry all the time. Not me, not Mr. Squid, but
in this case,
I'm hungry right now.
So even if Mr. Ballard has this, what he thinks is a safe harbor, oh, I was just talking about bullet fragment analysis generally, he is then saying, oh, and we'll have some more reports in this case soon that will clarify this. So he's actually talking about what he believes forensic experts will do and say in the future, which I think not only violates the rule in and of itself, but shows the overall problem with his excuse.
Then how about you don't misrepresent stuff in your motions?
Gray, if you can turn this around and say, since there's been all this negative media coverage, can I go on a public relations tour and state, in my opinion, Mr. Robinson is innocent, extrajudicially, beyond the fact that he has a constitutional right to the presumption of innocence, which the prosecution has an obligation to embrace and uphold, is because if I...
Yeah, but you also have the on the flip side, you also have the right for the state to put on a fair trial as well.
Yeah. They're representing their side. It's always about he's not getting a fair trial. What about the state's right to a fair trial? They have constitutional rights too. Interesting. A couple years ago, I wouldn't have been saying that. I'm not a big prosecution fan, but wow, they making it hard to be a fan of defense attorneys at the moment.
I know. It seems like the defense attorneys that make it really hard to be fans of defense attorneys get the most press coverage, and they are getting the most coverage on Law and Crime and Court TV.
And I love defense attorney. My favorite defense attorney was Johnny Cochran and Thurgood Marshall. But
those are people who actually got shit done, not wasted the court's time.
They can do that in response to media coverage, then this court's order and the rule are completely swallowed up. In other words, in a case where there is media coverage, which is not the result of interviews by the defense, I can go do those things, then this court's order has very, very little meaning. And Rule 3.6 has very little meaning. And that just can't be the way it works. So, at a minimum, their conduct was extremely reckless. And that, in the law, is the same as intent. But again, I don't believe that that's what this court has to make a finding in order to confirm the court's initial preliminary finding of a violation of this court's rules. It's interesting, Your Honor, that the state's attorneys have already decided that the recent media coverage about the bullet fragment analysis has prejudiced their case. Because they've been saying in this courtroom and in pleadings that we can't prove that any of the media coverage in this case has prejudiced Mr. Robinson. They've been saying, pick a better jury, have a better questionnaire. Maybe there's a venue issue, more peremptory challenges, individualized voir dire. And this court has said the same thing. But when it suits them.
Bye, Vicky. I hate that. Have to make a police report for a package theft. Oh, have a good one. You have a good one as well. And I hope you get that package. Ugh. And I hope the person who stole it gets karmic justice.
Yeah, I hate it. I hate that. Some idiot porch pirate hit us a couple months ago. Oh, and they got off of my sister's nail polish.
Oh, I'm sure she'd love that. Welcome, Spawn Raiders. We are doing part 3 of this evidentiary hearing. And if we can manage to get through it, we will be going on to the judge's decision, which happened 3 hours ago.
Yeah.
So.
Only like, what, 20 minutes, 54 to like 30.
Something like that. But we got to get through this first.
Yeah.
They say they've already determined that their case is prejudiced. And so they need to correct the perception in the jury pool so that they can have a right to a fair trial. And it's offensive to me, but it's deeply ironic that when it suits the state, we can't prove prejudice.
You're offensive to me. Your whole presence. The fact that your mom didn't swallow you is offensive to me.
And when it suits the state, they've already concluded that there's prejudice. Without even taking a moment to say to this court, we're very concerned about this. We weren't concerned before about all of the negative media coverage about Mr. Robinson and his life, but now we're concerned about the media coverage concerning this piece. And so, Judge, what are we going to do about this? I am confident that if the court received an inquiry from counsel that said, there's an urgent matter here, we'd really like to have a conversation with the court about what is acceptable under this court's order, this court would have convened a hearing. This court convened, as I recall, a conference call on like 6 hours notice back in September when the court wanted to manage this case quickly because things were happening. And the court's staff got everybody on the phone, and the court made some decisions, and then those decisions were docketed. There's nothing that stopped the state from asking this court to either clarify its order or approve some press release, even if it was over the defense's objection, that would be consistent with Rule 0.6 and the court's orders and Rule 3.8. So now, in my remaining time, I'm going to go to the remedies. I think
here we go.
The number one remedy in this case, Your Honor, is for this court to preclude the state from seeking the death penalty against Mr. Robinson.
And there it is. There it is. They want to strike the death penalty.
No, and then I think honestly that's been their whole goal. Their whole goal is to keep him alive. it's going to be a Koberger situation where like their whole goal
Yeah.
is to just keep him alive.
Yeah. And that's what some of the lawyers that were doing interviews with the news media, they were saying that
Lori said that almost made me spit my soda. Warning next time, please.
I would wait for this moment.
It is one
for
thing.
3 days.
I am very sporadic with implementing the death penalty. I don't think that every person who unalives somebody else should get the death penalty. Do I
Especially
think
with all the innocent, wrongful convicted people getting capital punishment, and after the fact, they're like, well, we're sorry, new evidence came out. I'm like, yeah, well,
do I think it's appropriate for some?
Oh, yeah.
Yes. This is one of those cases that you if he is proven to have done it, he unalived someone in front of 3,000 people, basically possibly giving 3,000 college students PTSD. So you didn't just affect one. I'm not saying ever that taking someone's life is a good thing. However, it's not like it was you got in an argument in an apartment and you unalived somebody.
Like I always tell people, do I agree with the death penalty? Maybe not. But if they want to choose to seek the death penalty and get somebody like a Dahmer or Gacy or somebody like that, I ain't gonna lose no sleep over it.
Yeah, I'm gonna start this because I gotta do mama duties real quick.
Yep.
The court said at an earlier time that if the court found there were violations of its orders, that it could order somebody to do continuing education, it could impose fines, it could do all kinds of things under the civil remedies. That is true. But what we are talking about is the state, without any guidance from this court, going out and trying to influence the public perception of this case, so that when people come into this courtroom, and they may be jurors in this case, they have been exposed to the state's extrajudicial statements about what the evidence will or will not show before the first witness is ever sworn to testify in the trial, before any exhibits are ever received into evidence. And as Mr. Ballard said, the media spin will never change. The media will do whatever the media wants to do, and I'm going to return to that as well.
You're not trying your case in the media.
What was going on here was an attempt to influence the jury pool, because that's the only thing that cures the prejudice, is correcting what the state is concerned are the perceptions of potential jurors. And so that is the remedy that is commensurate with the extreme recklessness and the motives of the state. We asked this court to compel some discovery, but Mr. Ballard was quite frank. We need to change public perception of what the evidence is or might be before we ever pick a jury. There are other lesser remedies, but we've already been through proceedings concerning how to remedy the pretrial publicity, the electronic publication of these proceedings. And the court has already said, in other contexts, we're going to have a more thorough jury questionnaire. We're going to have more voir dire. We're going to have individualized voir dire. We're going to have venue issues. I'm not saying that the court has promised a change of venue. That's not what I'm saying. But the court this morning said there may be an appropriate venue issue here. So there's no additional consequence for the state's misconduct here. We're already at the point where we've got to pick we have to much more carefully pick a jury because of what has happened in this case over the last 9 months. And now the state has compounded it horribly. We can't wait until we start picking the jury to find out what harm has been caused. So
couldn't the same thing be said for you?
The first remedy, the others are the remedies.
Like pot me kettle. Why doesn't he look in the mirror?
I don't want to be flippant, but I don't really care whether Mr. Ballard attends a continuing education program or not. All I care about is my client's constitutional rights. And
what about
Mr.
Charlie's
Ballard or Mr. Gray to
constitutional
the State
rights?
Bar, as Mr. McBride referenced, I'm not saying he suggested that the argument on the motion doesn't protect Mr. Robinson's constitutional rights. Mr. Levitt's sanctions weren't affirmed by the Supreme Court
I get
until
that they had
years
to
after
argue
the
this, but
That doesn't
they're
protect Mr.
relying
Robinson's.
on his constitutional right. It's like they using that as a shield for everything they argue.
It's one of the things that it's interesting to me that all of the things that they're arguing. Stop. They misrepresent. She's mute. She's trying to mute me by tapping the top of my. So they're misrepresenting facts, and then wondering why there's public outrage, and wondering why, and then it's just like the defense is trying to taint the jury pool the other direction. You can't have your cake and eat it too.
Yeah, I'm like, is there any wonder that the media is saying that finding guilty because of the stuff y'all doing.
Oh my God.
You got even lawyers out there saying that, yeah, this doesn't look good. Y'all doing delay tactics. It's not just ordinary people out there. You got lawyers like, yeah, nah, they trying to delay and drag this out.
Yeah, and I've tried not to listen to a bunch of other people talk about this because I don't want them to influence how I feel about things. Because at the end of the day,
I just think kind of interesting that you had lawyers just like, wow, like that's good.
Do not stop or do not mute my mic, please. Oh goodness. Extra nutty has been ordered, yes. I am against the death penalty in general, but I'm okay with it in the case of this attorney. That's well. Yeah. It's just one of those weird, and the death penalty is a hot button topic for a lot of people. However, this case, whoever is proven to have done it, not only unalived somebody in front of their wife and children, but gave thousands of other people potentially PTSD. So you're not just affecting the lives of one family, you're affecting the lives of thousands of families, which is where I'm like, you're harmful to society. So
he's not out on bail, is he?
Yes.
Hello.
Say, you can say hi to Nana.
Hi.
Yeah, it's the start of the baby squid show.
It's not done.
It just one of these. Let's all file motions as if speaking to the media is exactly the same as jury tampering, and if ignore the voir dire wisdom or voir dire to the or where we trust the jury to tell us the truth about what they've seen and heard. Yeah.
He's not out on bail, is he?
I see you.
No.
Oh, thank God. Okay.
Baby squid derailing the channel. Yeah, as if this channel ever had rails. You assume this. Thanks for assuming that this channel had rails to begin with.
This stream is the Baby Squid Show featuring guest Squid Procol and Flashfan.
Yeah. Yeah.
A baby?
You're the only baby here is you. Yeah. Okay.
Rights in this case.
Hot.
I just want to say one other thing, Your Honor. One of the reasons why extrajudicial statements are strictly controlled is because lawyers can't control the media. We can send them an email. We can make statements on the phone. We can sit for a 15-minute interview. Journalists will cut and paste and shape articles
I'm about
to
saying
fit
I'm
their
not
purposes.
making a comment.
And that's why it's extremely reckless to do what Mr. Ballard and Mr. Gray did.
Please.
If they had put out a press release, especially one approved by this court, that said the state stands by the allegations and the information, evidence will be presented at trial, Mr. Robinson has the right to the presumption of innocence until the trial has concluded, we wouldn't have this problem at all. Because the media, all they could do is cut and paste pieces of a press release that would be totally in conformity with this court's order and rules 3.6 and 3.8. And so they let Fox and TMZ and other media entities cut and paste whatever was important to them. But that doesn't relieve them of the responsibility, and it also does not undermine what I think this court unfortunately needs to find to be true, which is that Mr. Ballard's attempt to say he wasn't talking about the ballistic testing in this case is simply lacking in credibility. Thank you, Your Honor.
And counsel, I do have a question for you. So hypothetically, if the court finds a violation, do the interests of justice require a proportionate sanction?
Yes. And I think in light of the remedies that this court has already said are going to be necessary in this case, the sanction that I've suggested is proportionate. And it's in the interest of justice.
Okay. Thank you, Mr. Novak.
Thank you, Your Honor.
Turning to the state.
It's proportionate.
Assertion about credibility of Mr. Ballard. I view the evidence completely different. It seems to me that Mr. Ballard was extremely credible. His statements that were reported through several media entities all said the same thing, which were, I'm not going to talk about specifics of this case, but in general, when you have an inconclusive report, it means this. Did he say the bullet? Yeah, because he was referring to the bullet reference in the previous sentence. And that was consistent throughout all of the media that we looked at. And the Fox News story, when you see that, you can tell it cut off the last word when it begins his next sentence. That's how quickly it starts. And so and that's consistent. His testimony that he was referring to a general inconclusive result is consistent throughout all media entities here. But the reality is it doesn't matter anyway, because Rule 3.6b says parties, attorneys can reference matters in the public record. And this report was, in fact, in the public record by this time because defense counsel attached it to one of their pleadings. The court
Ha! The defense counsel put it in a pleading, therefore it's public record, therefore it can be talked about in the media. Go fuck yourself.
ordered it would be public.
I will translate lawyer speak to sailor speak. That was a long way of saying you put it out there first. Go fuck yourself. Sorry.
Free. Mommy, free.
Baby Squid isn't just a cute little baby to me anymore. She's now a study of what can I expect in the future with my little baby. I can't wait till mine is old enough to babble and ask questions. Take advantage of the time when they are non-mobile.
They,
Daddies.
they would they had sermon at church yesterday, and it's about because it's Father's Day, so they're talking about fathers and what if that's about the stuff. But it came, but it's like when you ask a question, they was quick to like you ask a question, religious question, leaders and stuff should be there. But they was like, if what the pastor, she was like, what is one of the things your parents say when you ask them why questions when you the kid, and everybody cut said so.
I now understand the no is a complete sentence, and I don't have to give you an explanation. But we are also in the F around and find out kind of situation where I can't tell her no right now. She just has to go and bump into things. Like she tried to run away from me and the coach at the gym, trying to corral her so we could leave this morning. And instead of her, she tried to run away from him. And she bumped her face into the rig. And I'm like, well, if you would have just listened to me and came to me when I said it's time to go.
That's how my mom taught me. She like, don't go in the kitchen when food is you're gonna get popped by the grease. Me being, I'm gonna do it anyway. When the kitchen got popped by grease, she like, see, I tried to tell you.
We can't even get that. No, but anyway, yeah, I love her hair. She wakes up like that. I just brush it and we go. And yeah, because she's gorgeous. Hey, Harry. All right, we're gonna start this again. And French.
And it was public. What Mr. Ballard's efforts at being general rather than specific show is a measured and thoughtful effort to correct the unfair prejudice that faced his client, not an effort to prejudice the defendant. That shows a measured and thoughtful, deliberate approach, not an intent to violate the court's order. The statement about what future FBI reports would say, that's misleading. That is not what the testimony was. Mr. Ballard testified. I talked about what the future FBI and ATF reports may say, and that was in reference to the motion to continue the preliminary hearing that talked about the lack of discovery of underlying data supporting the scientific reports. That's what the testimony was. Despite what Mr. Novak may want to say here, we're limited to what the testimony is here, and that's what the testimony was. The hypothetical, where defense says, well, taking the state's position at face value, then defense counsel could get up and say, I believe my client's innocent. That's comparing two completely different things. Rule 3.6, the comment to Rule 3.6 says, attorneys should not be saying they believe someone is guilty or innocent, right? That's not what Mr. Ballard said. He didn't come up and say, I believe defendant is guilty. That's not what he said. And with regard to the prejudice to the case, right? Mr. Novak talked about, well, it's not consistent that when it's the defendant being prejudiced, then we can handle all this through voir dire and expanded veneer and all those things. But when it's the state being prejudiced, you can't. You have to actually correct the record. Well, there's a difference here. Well, the first question is, are they being prejudiced unduly? Under 3.6, that's the language. Undue prejudice. Well, is it undue prejudice? When the evidence, and we all know this, everyone in this courtroom knows that media was misrepresenting the evidence here.
Yes,
See, and I'm not interrupting him as much because he's making sense and not annoying the hell out of me. I don't. He's making sense. We have a duty to correct the record and what's been misrepresented in the media.
And that's what the law says. See, I can find that where it says that what they can do, the scheduling, a request for a warning, or in a criminal case, in addition to something.
It's just interesting that it's the defense wants to have their cake and eat it too. They want it one way, but don't like it when the same thing that they are doing is done back to them.
It says notwithstanding paragraph A lawyer may make a statement that a reasonable lawyer would believe is required to protect a client from the substantial undue prejudicial effect of recent publicity not initiated by the lawyer or the lawyer's client. A statement made pursuant to this paragraph shall be limited to such information as is necessary to mitigate the recent adverse publicity. So if another attorney, like the defense, makes a statement, they have a right to correct it. Rule 3.6 of the professional rules of conduct in Utah, 3.6, I think that's subparagraph A. According to, if I'm reading this correctly, according to the website.
It's just like, and the media was responding to what the defense wrote in their motion and basically saying the defense misrepresented the evidence in their own motion. Oh my God, I can't. I can't help but laugh. Sorry. Don't be mad at me. However, it's one of them situations where I'm like, sometimes you just look at shit and you're just like, stop bitching about shit that you did. It's like me eating a cheeseburger and then wondering why I'm fat. It's like, you did it to yourself. Yeah, there's my legal argument from a non-lawyer because I am not a lawyer, never claimed to be one. However, I call balls and strikes like I see it, and this just proves that lawyers are shady, underhanded, and
I will say one good thing about this case. This made me want to learn to see what they talk about and see if they misinterpret stuff. Because I definitely I want to look at this rule and see what it actually says.
It's just, yeah.
That's what makes the prejudice undue, right? If there's a false narrative that's being pushed, that's undue prejudice. Under 3.6, that's when you step in and correct it. Now, that's why the comment to 3.5 or 3.6, comment 5 to Rule 3.6 is helpful, is because there are certain things that can create undue prejudice, such as an attorney's opinion on guilt. So if Mr. Gray had stood up at the initial press conference in this case and said, "Trust me, I am your elected county attorney. I believe the defendant is guilty," to correct that undue prejudice, yes, defense counsel could have got up and said, "Members of the public, it doesn't matter what the county attorney said.
Yeah, we see it all
the time. Believes. What matters is the presumption of innocence, and we've got to wait for a jury and all of those things, right? But that would be undue prejudice, right? Not the fact that he's been charged with a crime, not that there's an affidavit of probable cause and the contents of that, not that there's pleadings in the case and the contents of those pleadings. And that brings me to the point of, this is why it's so important that attorneys satisfy the duty of candor to the court, is because when an attorney files something with the court, we all know an attorney has a duty to this court to have candor and to be honest in what they represent. Why? Because then when the media reports on it, there's some assurance that there's some validity to those statements. That's why some of this, what we're dealing with, is so upsetting, is because it generates from a pleading that claims, that frankly was misleading, I think. And obviously the media all thought it meant what they said it meant. All right, with that, let me turn to, I think, what really is the crux of the issue here. You've got to start with the standard. The standard of proof is clear and convincing evidence. In order to find Mr. Ballard or Mr. Gray in contempt, the court has to find by clear and convincing evidence that Jeff Gray and/or Chris Ballard intentionally violated the court order. Now, defense counsel has taken issue with that intentionally language, but the issue they take generally comes from a case and a line of cases that predates the Von Hackey v. Thomas case, which is a Utah Supreme Court 1988 case, which promulgates the intentional standard. That same standard was reiterated in Sumner v. Sumner, a 2012 Utah appellate court case. These are cited in the state's brief, I should mention, as well as the Kohler v. Allen 2020 Utah appellate court case. That's the standard. proof by clear and convincing evidence that these attorneys intentionally violated your order.
What?
In this circumstance, the defense can't prove, and I don't think the court can find, the actus reus, much less the mens rea, which is much more difficult to prove. When you look at the actus reus, these statements did not violate the order, which explicitly refers to Rule 3.6. That last line of the order says, right, this order does not preclude the attorneys from speaking to the media. See Rule 3.6b, right? 3.6b allows attorneys to talk about material in the public record. And 3.6c, which allows attorneys to correct extrajudicial statements that prejudice their client's rights.
Yep, that's what I just read.
And remember, this is the state who was defending this, but remember, the state, their client is dead.
Yep. Their client, in essence, is the family, Erica Kirk, the wife of Charlie Kirk.
But in all actuality, the client that they are defending and they are getting justice for is dead.
Yeah.
So if you want to think about it in like a plaintiff defendant kind of situation, like a civil case, their defendant, their plaintiff is dead.
Yeah.
So, and I will have to go do mama duties in a second because someone ran to the bathroom.
Yeah,
So,
I think we're almost done with the this argument, and then it's the hearsay argument.
yeah, this argument, I'm finding it really easy to just listen to because he's making a lot of sense.
Yeah.
It did not violate the rule because the reference to the test, the report from the ATF, was a matter of public record, docket 284, which is specifically allowed by the rule. But Mr. Ballard, in demonstrating his measured response, took an additional step to avoid potentially prejudicing the defendant's rights. Rather than saying, I'm going to read to you the report, media, that talks about this case, the bullet in this case, and the results. I'm going to read to you the report that says, not only the part that the defense included in their pleading, that they could not tie the bullet, that they could not identify that bullet as having been fired from that gun, but they could not exclude it. And not only that, but they could tell this is a .30 caliber class round. Mr. Ballard did not do that. He could have under 3.6b, but he didn't. Why didn't he? Because he was taking a measured and deliberate approach to avoid violating this court's order, to avoid violating his ethical duties. Under 3.6c, he was correcting an unduly prejudicial media to protect his client's right. Why is it unduly prejudicial? Because it was false, right? This narrative that the bullet didn't match was false. Everybody in this courtroom knows that that narrative was false, and he was correcting that narrative. It's hard for me to think of a circumstance where 3.6c would be more directly at issue. We have here perhaps the most high-profile murder case in the world, certainly one of the most high-profile murder cases in Utah's history that has generated extraordinary attention from the media and from the public. We have here, not only that, we have here reports that are claiming that are misrepresenting the evidence and claiming that it completely exonerates.
Across the world, the main article that kicked all this off was the Daily Mirror or something like that, a UK tabloid.
Oh yeah.
So blame Spawn. Oh, thank you. Hi. Thank you.
The defendant. And those reports are false. Right? Hard to see a circumstance where 3.6c would not be more at issue. So, Your Honor, I don't think the court can even find the actus reus here. I don't think the court can find that the statements that were made by Mr. Ballard violated 3.6b or 3.6c and therefore violated the court's order, much less that Mr. Ballard and Mr. Gray intended to violate the court's order. When it comes to the mens rea, the intent, you can see by the statements, by the testimony, that both Mr. Ballard and Mr. Gray were deliberate. They talked about Rule 3.6. They were aware of 3.6, 3.6c. They were aware of other cases where corrections of the record had been brought up, including by lead defense counsel here, where she corrected the public statements and said the prosecutor should too. And they made measured statements, Mr. Ballard made measured statements to the media that were deliberate and did not go beyond what the rule allowed. He did not say, I believe he's guilty. He did not say, like Mr. Levitt did, I believe my witness. We believe the witness. He did not refer to evidence that would not be admissible. He referred to evidence that was in the public record. Finally, Your Honor, I think in conclusion, the defense has not shown and the court cannot find proof by clear and convincing evidence that Jeff Gray or Chris Ballard intentionally violated the court order or violated the court order at all. As I mentioned before, we have taken this matter seriously. At the very outset, you can see that the state, the day the defendant was arrested, was sending out letters to the media, to the police chiefs and the law enforcement agencies saying, be aware of these rules. If you talk to the media, you have to abide by these rules. We suggest you don't talk to the media. If you have questions, talk to us. You can see that we've taken this very seriously from the outset. We've taken it very seriously up until this date. We have a duty to justice and to our client to make sure that our client gets a fair trial and that the truth is out there. And this, of course, this issue has brought the issue front and center to us, and we've discussed it, and we've discussed how we can be absolutely certain that we do not cross the line. We don't want to cross the line. We want to stay as far away from that as possible. We believe we want the state, we want Mr. Kirk, we want his family, we want everyone, including the defendant, to receive a fair trial. We don't want to do this again. We want to do this right the first time. We believe we've done right this far, and we will exercise extreme care to continue to do right here, even if that means revising some of our protocols in interacting with the media.
Thank you, Mr. McBride. I do have one question for you with reference to
Hey, Spawn.
Hi, son.
Hello, sweetie. I'll talk to you first, my darling. Hello,
You're
my
very
sweetness.
loud, Spawn.
And what?
You're very loud. Let me turn you down a little bit.
Hello, sweetie. I'll talk to you first. Mummy and Flashfan can wait because they were rude to Uncle Spawn. Hello, sweetie. You been a good girl?
Yeah.
Okay, good. Yeah. Oh, what's that? What is that? Oh, nice. Yes. Good.
Okay. Anyway.
Yeah, so hi everybody. First of all, yeah, you crack Flashfan. I'll deal with you in a minute. First, it's ladies first. First of all, hello everybody. Hope you're having a good stream. Blame the UK. Yeah, absolutely. We've had the best news besides Donald Trump trying to play golf. We've had the best news ever. Prime Minister Keir Starmer has resigned. Yes,
He has.
Yes, he's resigned. He's so basically, when he's gone, they're going to put an interim prime minister. He's going to carry on. They're going to put an interim prime minister, and hopefully, like if Farage gets in, I don't want to go off topic, but if he gets in, there is going to be absolute hell to play in this country. And we've had 178 civil wars in this country, lasting from 1 minute all the way. Bon appetit. Crunch, crunch. I'll wait till you let go. And basically, all the way up to over 100-year-long wars. So I'm not into this religious stuff, ideology, creed, color, what hole you pounce. All I care is humans are humans. But that was probably the best news, to get that absolute pleb out of that position, because hopefully we'll get someone who's got good relationships with America, so we can rebuild whatever we had, as long as it's beneficial for both sides. And let's make Great Britain great again. That's going to be one hell of a baseball cap with those initials on that baseball cap. Wait a minute, Spawn Troopers. Wait, what? I tell you one thing, all right? Baby Squid, has my full 100% protection, and not just for me. You think I'm dangerous? Wait till my queen tells you what she will protect that little one with.
You have the frying pan.
Yes. Now, Mr. Flashfan.
Uh-oh.
Your turn, sunshine. Step up. How you doing, brother? It's good to hear you. Good to see you, mate.
Great day for you as well.
Yeah, so make Britain good again. No, wait, no. What you need, make Wales better than. Yeah. Okay. Yeah.
Anyway, we're getting derailed even more than
yes.
normal.
Yes. Well, you should know by now. I had a fantastic stream. I did redirect over to you because I knew that you were. I know that you were covering this today. I'm going to be quiet because obviously I haven't caught up on this one. So I'm just going to sit in, listen, and once in a while crack a joke. Yeah. Here's one for you. Americans drive on the right side of the road.
As do most of the world.
Just don't ruin the joke. Don't ruin the joke. Right? I know that in the Navy you don't have humor, so don't ruin the joke, right? So in America they drive on the right side of the road. In Great Britain they drive on the left side of the road. But in Russia, who needs roads? We drive everywhere. So
And on that note, we're restarting this.
To the final page of Exhibit 3, and in the context of correcting the record and evaluating undue prejudice, how does the state contend that Mr. Ballard's statement, and I'm quoting, "He is presumed innocent. The ultimate decision will be up to the jury. We believe we will be able to overcome his presumption of innocence."
Thank you. Yes, first off, we don't know the exact order in which the statement was received. But I think there's two things that are important here. One is the reference to he is presumed innocence, right? That shows that Mr. Ballard was intentional about making that clear, right? The jury will find guilt. That last statement, we believe we will be able to overcome the presumption of innocence. This is a reaffirmation of the state's certification under Rule 11 that we have the evidence to proceed with the case. In good faith, we believe we have the evidence to proceed with the case. Every attorney that files a pleading in this courtroom certifies that they believe the matters contained in that pleading are supported by evidence. And that's what this is. It's a recertification. We believe we have the evidence to prove this case. All of these media reports do not undermine that good faith certification that we made when we filed the case. And I think this is where it's helpful to look at. I have this here. We cited a case, Kansas, State v. Wright, 583 Pacific 3rd, 174, where the prosecutor in that case in jury selection. So this is a much more direct, this is right to the jury pool who's going to try the case, right? In that case, the prosecutor says to them, let's see if I can find this quote.
Let's see.
Oh, I meant to cover this. In State v. Wright, 583 Pacific 3rd, 174 on 194, this is a Kansas Supreme Court case from 2026. The county attorney, speaking to the veneer, the jury panel for jury selection, says this: "So as the county attorney, my job is to prosecute cases that are brought to my office that I feel we can prove beyond a reasonable doubt." Then he continued, "That is the burden that the state willingly accepts when it filed charges and brings cases forward. So the state understands its burden and intends to prove that through the course of evidence this week." And the Supreme Court ruled as follows: "Rather than an improper personal opinion on Wright's guilt, the prosecutor's comment here simply explained the prosecutor's role in the proceedings and reiterated the state's burden of proving guilt beyond a reasonable doubt. A prosecutor in a criminal case cannot ethically prosecute a charge that the prosecutor knows is unsupported by the evidence." That's what was happening here, Your Honor, is saying Mr. Ballard testified. This answer was in response to the question, do you still have a case? Right? Does your case fall apart here with the evidence? And his opinion was not, I believe he's guilty. It was an opinion directly tied to the evidence. We believe we have the evidence to prove this case. And it's nothing more than a certification that all attorneys make when they make filings, and that the county attorney made when filing the information in this case. It's much less prejudicial than anything the attorney said in State v. Wright, because it's directed to the media rather than the jury veneer. And it's not prejudicial anyway. I don't think anyone would be surprised to learn that the prosecutors in this case believe they're going to be able to prove it. In fact, I think if the public thought we were prosecuting cases,
Shocker. I don't think anybody's going to be surprised that the prosecutors think they can prove this case.
Hell yeah.
They
have an entire week for a preliminary hearing. If that doesn't say they got a lot of evidence, I don't know what does.
It's one of those situations about it's just, and I'm struggling putting this into a complete sentence that is going to be coherent but succinct. It's just one of those situations of like the fact that they have to reiterate, yeah, we think we have enough evidence, and that's what we told the media.
And they still, every hearing since this case has started, every time a hearing starts, they ask the judge, what's the status of discovery? The state say, we just handed over this. So they still handed over discovery.
Yeah, because they're constantly getting it from, I think, when I looked at the motion or one of the discovery motions, it was like 18 different law enforcement agencies.
Now, a lot of that stuff might be subject to like motion to suppress or whatever.
Well, and a lot of it might be overlapping.
Yeah.
That's the other problem too, is a lot of it might be overlapping because those different law enforcement agencies might not talk. They both might have some of the same witness statements or the same camera footage from their separate investigations.
Yeah.
Because when it's all hands on deck, everybody collects what they can. Well, they might have collected some of the same stuff.
That we can't wait till 2 weeks, because that's when we finally get to see some of this evidence. When this
The 6th.
6th. Yep.
July 6th. Oy. I'm hoping that Papa Squid can babysit that week. Or Mama Squid can babysit that week. Well, we'll see.
we did not believe we could prove, that would be frankly shocking, because it wouldn't make any sense. I think everybody knows that we believe we can prove this case, and we intend to do so through the evidence, not based on personal opinions that are endow it on us through our authority as prosecutors, which seems to be what Levitt claimed in that case.
Thank you, Mr. McBride. All right.
Can I beg the court's indulgence for 90 seconds?
I will give you 90 seconds, Mr. Novak.
Thank you, Your Honor. I think
Let's see how.
we all want the court to
90
be
seconds.
90
clear on the
seconds.
law with respect to the third element and intentionality.
Longest
And Mr.
90 seconds of
McBride
your
is
life.
Not correct when he says that all of the cases that we cite for the proposition
And people say that a minute and a half isn't a long time until you listen.
That's
to
the
Novak.
that's the lawyer trap. They say that every time they be questioning the witness, they be like, I just had one more question, and one more question turned into like 20 more questions.
This is the Mark Diller of the West Coast, ladies and gentlemen. And if you don't know who Mark Diller is, he is a lawyer for the John O'Keefe family.
Now I'm really gonna have to catch up on something on here. I think they got a motions hearing today, apparently. I think I saw a live stream for it. Like, oh.
And Malin, thank you for the 100 Swedish krona, just because. Love you too. Thank you. I appreciate that. Oh. You're struggling. Why are we even here spending a lot of money that doesn't need to be spent? Amen.
that violation of an order enjoining conduct requires proof of intent predate Von Hayek. That is not true. And so what I want to just remind the court is that in 2019, the United States Supreme Court said, and this is at the bottom of page 10 of our reply, the United States Supreme Court said, quote, "We have explained before that a party's subjective belief that she was complying with an order ordinarily will not insulate her from civil contempt if that belief was objectively unreasonable." That's Taggart v. Lorenzen, a 2019 Supreme Court case. And in the same year that Von Hayek was published, the United States District Court for the District of Utah said that civil contempt for violation of a court order need not be willful. And now I'm going to quote from the District of Utah opinion. "In order for a party to be cited for civil contempt, a court must find that the party violated a specific and definite court order and that the party had knowledge of the order sufficient to put him on notice of the prescribed conduct. Nevertheless, the disobedience in a civil contempt need not be willful because the purpose of civil contempt sanctions is remedial." That's In re Skinner, a 1988 published decision in Bankruptcy Reports, District of Utah.
Thank you, Mr. Novak.
And I have nothing further unless the court wanted to inquire of me concerning anything Mr. McBride said.
No, thank you.
Thank you.
All right, we're switching gears, going to the motion in limine to exclude hearsay statements as mentioned in the briefing. Again, I will note that
I'm
the court
interested
has
in know what
examined
you're
those
going to think
briefings.
about this lawyer.
Okay.
I'm interested to see what you're going to think about Michael Burke, because this is
That was the one who was the Menendez brothers
Al
lawyer. Right?
Menendez, attorney from '93, their first trial. Yeah, he's been a lawyer since 1978,
Okay.
so he's the
in
most
detail.
experienced attorney
And
here.
so the court wishes
Oof. Yeah, the defense attorney speaking might be the antidote for insomnia. Yeah, that was at 1.5 speed too.
for limited argument as the briefing provides a lot of guidance from both sides on the parties' positions. And so if the parties would like to take up to 15 minutes to argue that, you certainly can. And then we'll go to the final issue that Mr. Novak brought up in the beginning. And as this is defense's motion, we'll turn to defense. Mr. Burt.
Morning, Your Honor.
Good morning. Well, afternoon now.
Afternoon, I guess. Judge, as the court knows, and as you've just noted, there's been extensive briefing here. I'm not going to get into all the technical arguments, and there are many here. But the briefing outlines 6 different bases for the court to find here that the use of hearsay evidence in this particular preliminary hearing in this death penalty case is unconstitutional under the federal constitution. The state constitution has separate rules, as we outline in the brief, and I know the court's familiar with those. But the constitutional issues raised under the federal constitution are unique. For the most part, they have not been addressed by any Utah court, with one exception, and that's the Confrontation Clause objection that is addressed in Timmerman. But as to our other arguments, procedural due process, equal protection, the Sixth Amendment right to counsel, those issues have not been addressed. And there's, of course, one issue, separation of powers. That's a state law issue. That has also not been addressed by any Utah court. But I wanted to take just a few minutes with the court, if I could, to outline why this motion is important in this particular case. I don't think that's really outlined in the motion, but I think it's important for the court to consider. And I know the court has not reviewed the exhibits that have been submitted to the defense from the prosecution in terms of what they're going to present at the preliminary hearing. But I'll represent to the court that for the most part, the state, and I'm sure they'll correct me if I'm wrong on this, intends to rely almost exclusively on hearsay evidence at this preliminary hearing to make out the elements of the charges and allegations, and especially the death penalty eligible allegations against Mr. Robinson. And probably most problematic from our standpoint is that the central witness who's going to be presented against Mr. Robinson is a witness who the prosecution and the federal government have given promises of immunity to. And in lieu of putting that witness on the stand and subjecting him to cross-examination, they met with this witness outside the presence of the defense, asked a series of leading questions that the witness was asked to agree to, videotaped it, and the state proposes to introduce that into evidence. In addition, a prominent feature of the evidence at the prelim will be a number of forensic reports by federal and possibly some state law enforcement forensic examiners. And those reports, for the most part, are simply conclusory opinions about certain findings that were made. There's no indication on the face of the report as to the methodology that was used or the reliability of those methods. The reports are simply going to present the court with conclusions. And then the state is going to rely on Section 1102 of the Rules of Evidence to urge this court that those statements by law are reliable evidence. And that's the gist of the problem here, because 1102, in combination with Article 1, Section 12, essentially removes what was supposed to be this court's function at the preliminary hearing, which is to assess the reliability and the credibility of the evidence. And the intent of Article 1, Section 12, if the court goes back into the legislative history, was specifically to remove the court's discretion to decide whether certain evidence was reliable. And that's where the separation of power issue comes into play. Now, that, we say, violates the federal constitution in a number of respects, and also the state separation of powers provision. But I wanted to point out to the court that the state's position on this issue is really contrary to the position they've taken on almost every other procedural issue that has been raised in this case. And the prime example is the one just presented to the court in connection with the OSC. One of the things that Mr. McBride said was, we have a duty to make sure the truth gets out there. And similarly, the defense has a duty to make sure the truth gets out there. And how they do that in this system, traditionally and historically, has been through the use of cross-examination, confronting adverse witnesses. Another example of the inconsistency that's being urged upon the court in the state's opposition to this motion. The court will recall the state's position on our motion to exclude cameras from the courtroom. And Mr. Grunander began his argument to the court with this statement: Your Honor, mischief lurks in the dark or in secret, or that's at least how many people view the workings of government, even the courts. And while this is primarily the media's fight here, we do not represent the media. We strongly support open and transparent proceedings in this case so that the public will trust the process here. There are conspiracy theories that abound. There are questions being raised. And the best antidote for falsehood is the truth, is accuracy, is the actual real proceedings. And that's at page 214 of the hearing on April 14th. And similarly here, Your Honor, the defense's right to cross-examine and confront adverse witnesses, immunized witnesses in this case. We're going to provide the bulk of the evidence against Mr. Robinson. The purpose of our doing so is to get at the truth, to lead.
I don't hate him as much as I hate Novak.
Okay.
I mean, his voice is very old man. No offense to elderly men, but y'all kind of start to sound monotone after many, many years.
Not much has changed except for maybe like the tone and voice getting a little softer, but he sounds like that back in 93.
But it's you already had your gummy. You don't get one more. You can have another one tomorrow. It's just one of those situations of like, I don't necessarily agree with what he's saying. I understand you want to get to the truth, but you're trying to circumvent something that has been a thing in our court system for 250 years. Yeah. Like, what makes your client so special that hearsay is not allowed for probable cause? Like, why is he special? What makes him better than any other defendant? That's what I'm not understanding. And that's the argument that I think he would have to overcome in order to get this approved. And I don't know if you can do it because you're going against 250 years of precedent in virtually all 50 states. I mean, there's a good chance that I could be wrong with all 50 states, but this is hearsay is a thing at probable cause because that's what probable cause is. It's like, gee.
The transparency. And one of the articles that the state has cited to the court as indicative of an analysis that's relevant to this issue is an article by a former district attorney who, this is the Bowden article that the state cites. And one of the things that Mr. Bowden, former prosecutor, says in his article that the state cites is he's addressing the issue of why it's important to have adversary proceedings and pretrial proceedings such as preliminary hearings. And he says, this is at page 1148 of his article, a system without adjudication lacks transparency. The public normally has no way of learning why prosecutors make the offers they do or why certain cases reach certain outcomes. The opacity prevents the public from understanding how criminal courts function. It frustrates journalists and scholars who wish to study criminal courts, and it distorts democratic feedback as voters are left with little idea of how these institutions work. And the court, in its rulings on public access, and even this morning, you have also emphasized transparency as a goal of the criminal justice system. So this motion asks the court, how can we further transparency by relying exclusively, or almost exclusively in this case, on hearsay evidence that implicates Mr. Robinson in a death penalty case. And we say to the court that if the court looks carefully at the cases we've cited on the federal constitutionality of this practice, the court should determine that it's simply unfair to proceed on the basis of hearsay in a case where Mr. Robinson's life is at stake. The federal constitution requires that people who are facing parole revocations have the right to confront and cross-examine witnesses. The U.S. Supreme Court has determined that people facing probation violations have a right to confront and cross-examine witnesses. The state Supreme Court has determined that people at suppression hearings have the right to confront and cross-examine witnesses. The state Supreme Court has determined that people who face sentencing have a right to confront and cross-examine witnesses. And we say that due process, equal protection, and the other provisions we cite all point in the same direction, which is that the court should not allow the use of hearsay to make the determination in this case that Mr. Robinson should or should not be bound over for trial. And I'll be glad to answer any questions the court may have. I know the briefing's fairly extensive, so if the court does have questions, I'm prepared to address them.
I do.
And yes, Malin, the death penalty is on the table. It's been on the table since the very beginning.
Yeah, they trying to get it struck out of this.
Yeah, that's one of the things that the defense wants.
Mommy, butter.
So, but we shall see.
I have one question. I'll be asking both sides this question.
Sure.
I'm doing some research on this.
And you noted it that it wasn't reviewing the exhibits ahead of the preliminary hearing in order to go in with an open mind and weigh it accordingly. Is it your request that the court review the proposed state's exhibits that relate to this motion prior to the preliminary hearing?
Your Honor, I think it would be helpful to the court to do that because I think the court would then have a better context of just how central hearsay is going to play in this case. And also, especially in regard to the crucial witness, the immunized witness, how the state structured that hearsay. And I think if the court did that, it would clearly see the importance of cross-examination and confrontation. So I would have no objection to, and I would urge the court to do that.
And do you have those exhibits, those exhibit numbers? And if you need time to confer with your team as I go to the other side, I don't expect you to just come off with those numbers off the top of your head.
Sure. I know the court, the state provided those to the court. I think there was some email traffic about how the court then gave them back to the clerk, but I think they're still in the clerk's possession. The state will correct me if I'm wrong on that. But
Right.
they're the state's exhibits, so.
No, you're right. I know, but I'm wondering if there's specific ones that you want to identify that relate directly to your motion that you wish the court to review.
Yeah, sure. And if I could have a minute, I'll identify what those exhibit numbers are.
All right, so I'll turn to the state. And
Great.
Again, I'm not trying to put you on the spot there. All right, Mr. Ballard.
Thank you, Your Honor. The Utah Supreme Court has already rejected the defendant's argument in State v. Timmerman. This court can't overrule the Supreme Court. And I think it's fundamental.
Damn
it's
straight it
important to think
can't.
about the fundamental reason why the court held in Timmerman that the Sixth Amendment right to confrontation does not apply at preliminary hearings. And it's because of the very, very low burden and low standard that the state has to meet at a preliminary hearing. All we have to show is probable cause.
I agree with this, Snipe. This is for show to people who normally don't watch hearings, much less trials, trying to make it look like the big bad state is doing things wrong.
This is a unique situation. Sometimes you hear pre-trial hearings, maybe like 1 or 2. Every single hearing ever since the pendency of this case has been televised.
Well, also, there's you from the very beginning, even people who I normally watch and agree with, like commentators,
Yeah.
are saying things. And I'm like, that's not how this shit works. Like, tell me you don't watch trials without telling me. It's like, that's not how any of this shit works. Tell me you are not a true crime podcaster without telling me. It's like, and you're telling your audience of millions of people information that is not true.
Yeah.
And then millions of people get this information and think that they know what the hell they're talking about, and they really don't. And it's so annoying because it's happening on both sides. And that, I believe Snipe Hunter is right. And this is the defense just trying to do all of this for show to take advantage of the court of public opinion in the eyes of the people who have absolutely no freaking idea what the hell is going on right now.
And that's probably why this case is going to go pairs tits up, and you're going to get the same crap that you got with the Amber Heard stuff and everything else. I mean, you know, it's like maybe this is exactly what they want for this case to go tits up.
Yeah, they're trying
to. Now, somebody did ask me, like, do you think this case will create case law? Like, would there be laws written about this case after those? Like, I don't know. I don't know.
I really don't think so. I don't think so. What I do think this will do is show millions of people who have no idea how our court system works,
Yeah.
And it might get more people paying attention to the way our court and our criminal justice system actually works. So when people tell you our shit needs to be reformed, now you see why.
Maybe that's exactly what they're trying to do, is to confuse the shit out of people. Because, like, look, I'll be the first one to put my hands up and say, hey, I don't know about your legal system, even though it originates from the British legal system, but do evolution of your own laws over there. You know, it's a complete different. And if you don't know about the law system, of course, they're going to play this game and confuse the shit out of people.
I'm finding myself agreeing with Snipe Hunter most of the day today. What is happening to me?
That's scary.
Yeah, mark this one in the books. They're hoping to get a plea deal to save his life.
I doubt they're getting a plea deal. I can see it with the Goldberger situation, but a case this big, yeah, I can't say for sure. But I'm like,
Malin. Malin said, I will put my hand up in the air and state I don't know shit about the USA courts or how the USA courts work, but hey, I'm learning. You get a pass because you don't live in this country. English is not your first language. Like, you're not a lawyer. Like, it's understandable that a citizen of another country does not understand how our legal system works. However, when people in our country who were born and raised here, who worked as cops, don't understand or are telling people that things are not, that things are happening, and it's like, that's not how this shit works. It's like, you were a cop. You're supposed to know these things. Like, it's.
Do I get a get out of jail card because obviously I'm not an American, or
Most of the time.
No,
I don't have a fever.
I just think that, like, this is what with big public freaking cases like this. I mean, God, this is like an assassination of someone, and of course they're playing the game. You can tell they're playing the game.
Yeah.
But it's like at the end of the day, it's up to the judge to decide, what he wants to do. Look what happened to the last case with that young lad who got stabbed. The judge kept the cameras out of the court.
And now stuff is finally starting to come out in the media, and it's like, oh, look at that.
Yeah, he has all these evident images and body cam footage. I'm still trying to locate all that stuff.
Yeah, but it's a double-edged sword, no matter how you address it.
Yeah.
you know. So I'll mute myself again.
They're afraid to deny or disagree with this guy. Yep.
The magistrate at a preliminary hearing isn't making any factual findings. The issue is just whether there is a reasonable probability of that an offense was committed and that the defendant committed it. And in making that decision, as Your Honor well knows, you have to draw all of the inferences in favor of the state. You can't weigh conflicting evidence. You can make only very, very limited credibility determinations. So even if the defense could impeach a witness to some degree through cross-examination, like the fact that this witness has been granted immunity, it doesn't matter at the preliminary hearing because the magistrate's duty-bound to ignore those blemishes and draw all reasonable inferences in favor of the state. So even if the state's only witness to a robbery was a convicted forger who wasn't wearing his glasses when he saw the robbery and who had a grudge against the defendant, even if the defense could bring all of that out on cross-examination, it's irrelevant to the probable cause finding because it's such a low burden. That's an extreme example. I don't think the state would ever bring charges in a case like that, but we do have an example that is similar in scope to that, and that's State versus Drozbecki, that I think is how you pronounce the name, Droesbeke. That's 2010 Utah App 275. In that case, you had a child victim of sexual abuse who reported the sexual abuse to law enforcement, reported it during a CJC interview, but then took the stand at the preliminary hearing and recanted those allegations.
That's one of the things of that law. So I looked it up, and it says permitted hearsay. Reliable hearsay includes hearsay already admissible at trial. There's some case law. Scientific, laboratory, forensic, medical, and autopsy reports. Statements from child victims reported properly.
I think
made by a non-testifying peace officer and witness recorded statements that are made under oath or carry penalty for making false statements, which applies for that.
I think I know where they're going with this specific case and why it's brought up. A child says something happened, gets on the stand, is in front of a lot of people, recants their statement, but they had told a parent.
And potentially in front of the accused, witness intimidation, because in front of the accused, you don't want to testify because you're afraid of this person.
Well, what I mean, but they told a parent. That's hearsay.
Yeah.
Technically speaking, telling your parent and then saying, well, no, that didn't happen, but you told your parent that it happened. Technically hearsay. So I think that's where they're going with this specific, and why this specific case was brought up was the hearsay.
Yeah, I'm gonna find all these rules that
sufficient evidence under that situation to bind the defendant over, even though the witness recanted those allegations, because there was a reasonable explanation as to why the witness might have been telling the truth when she reported to the police and during the CJC interview, and why she might have recanted at the preliminary hearing. So that's the standard that the court is applying. And so defense talks about we have to have reliable evidence. And the state absolutely agrees that we have to have reliable evidence, but reliability, the degree of reliability depends upon the circumstances of the proceeding. So is hearsay sufficiently reliable for a conviction beyond a reasonable doubt at trial? Certainly not. But is hearsay reliable enough to be able to make this low probable cause finding? Yes, it is. And that's.
Remember, this is not the trial.
Yeah, no.
They are not taking this evidence to trial. This is probable cause. It's like the cops smelling marijuana and having probable cause to search your vehicle. It's a very low bar. Okay, then tell me all about it. But it's a very low bar to get over. Quiet, Angel. It's not beyond a reasonable doubt like you need at trial. It's not metadata for text messages. Like there's a higher bar at trial than it is for a preliminary hearing. Preliminary hearing, you need probable cause. It's like the cops looking in your window and seeing somebody unconscious in the back of your car and wanting to see if that person's alive. Like they need probable
99.9% sure that D's gonna get bound over for trial.
Yeah, and they're just delaying the inevitable. Can you say pecuniary advantage? I mean, I would still say
say,
it
I
was
don't even-
better than Tug's first attempt, but you know, I don't know.
Why Timmerman held that the Sixth Amendment right to confrontation does not apply at preliminary hearings, and that's why nearly every other state court that has examined this issue has found that the Sixth Amendment right to confrontation does not apply. Timmerman collected those cases as of 2009. You've also got the Ninth Circuit in Peterson versus California, and we've included all of these cases in our brief. In fact, if this court granted the defendant's motion, it would be going where no other court has gone before. This court would be the first court to find that the Sixth Amendment right to confrontation applies at a preliminary hearing.
Going where no court has gone before. That's not something you want to
Timmerman
do.
is clear that the Sixth Amendment right to confrontation doesn't apply at a preliminary hearing. Defendants trying to rely on other federal constitutional provisions. But defendants' attempt to do that violates the rules of constitutional construction, legal interpretation, because it would create contradictory constitutional provisions. What defendant is trying to say is even though the Sixth Amendment right to confrontation, which we know would provide the right to cross-examination and therefore prevent the state from relying on hearsay, even though that right doesn't apply at the preliminary hearing, there is some other constitutional right that could somehow indirectly provide that right. But then we would have two conflicting constitutional provisions. And that's not how we read the Constitution. That's not how we read statutes. We read them to be in harmony with each other, different provisions to be in harmony with each other, and to not render a different provision superfluous. If you could provide the right to confrontation through the Sixth Amendment right to counsel or 14th Amendment right to due process, then what work is the Sixth Amendment right to confrontation doing? It just doesn't make sense to do that. So that's exactly why the Ninth Circuit in Peterson versus California said it's illogical to conclude that the substitute for a grand jury indictment, which is the state preliminary hearing procedure, must contain greater protections than the grand jury provides for itself in the federal system. So if the federal system, the equivalent to the state preliminary hearing is a grand jury proceeding. The grand jury proceeding allows the federal system to determine probable cause to require a defendant to stand trial. The defendant doesn't have a right to be present in those proceedings, doesn't have a right to representation, doesn't have a right to cross-examination, or even to present exculpatory evidence. If that type of a procedure is constitutional, then Utah's preliminary hearing procedure is certainly constitutional. I could go through each of the different constitutional provisions that defendant has relied on. I'll do that very briefly, just summarize the reasons why we don't believe those apply. The Sixth Amendment, even...
So I agree with what he's saying. I think making a stretch to federal courts is a little far.
So is he saying that they can't present a case at preliminary hearing, which that's not accurate? They can call witnesses. They rarely do because it tips their hand, from what I understand from reading and hear what other lawyers say. They rarely put on evidence at a preliminary hearing, just so the state doesn't know what they have. But it can be done, from what I understand.
I just have to address my mom's comment real quick. Baby Squid is learning fast from mom. She's giving her opinion too. Yeah, raising a strong, independent child is all fun and games, and you think your goal is to raise a strong, independent, productive member of society until she turns that strong, independence and personality against you. It's all fun and games until she looks at you and goes, "Nope." Excuse me, ma'am.
My mom was good. My mom would intimidate you. You tell everybody, no, she's like, what did you say? I'm like, yes, ma'am.
That was my grandmother.
I say.
Yeah.
That little
Okay.
angel can't do anything or say anything wrong in
Okay.
my book.
Good thing we're not in the same book.
You can look at that. Look, you can look at me in that tone of voice, young lady. However, little princess has carte blanche.
I catch a car.
Yep.
I catch
Oh, and just a Nutella update. Walmart did have Nutella. My dad wanted me to get a small jar for his house, so I'm taking one of the small jars that's in my house that's unopened, giving it to him, and we bought 2 large jars today. So,
All right. And I've just noticed you are now on the new restream, correct?
yeah.
Word of advice, go into your settings and have a look at the volume adjustment. Other than that, I'll talk to you afterwards. But don't do that now. Concentrate on what you're doing. And then we'll talk about it afterwards. And by the way, I am finding this case very bizarre.
Oh, yeah, definitely. This is, and that's stuff you see every day.
Yeah, but Flashfan, what I can't understand, why are they bringing a case up when it comes to child abuse? This has got nothing to do. I mean, it's like,
Well,
He's just reading what the law, the article section 12 thing says.
it was for that it was for the why hearsay is allowed in court in probable cause hearings. In situations like that,
Some reliable hearsay allowed. They had limitations, but that's one of the things that it falls under that allows it to be
Yeah.
admissible. So
They-
we're just reading the.
they brought up that case because that is where a child said something happened and then all of a sudden they recanted their story, but they had told enough reliable people that the hearsay that yes, I was present when the child said this was enough of a bar to bound over for trial, where that person I believe was later convicted. So
Maybe I should go to law school because this got me reading all sorts of laws because I want to see if they making sense.
it's one of those situations where a situation like that is a perfect example of hearsay and why hearsay should be allowed at preliminary hearings. So he was using that as an example. So so that's kind of the perfect example of it's technically hearsay, but it's reliable hearsay. You told cops, you told your parents. Those are reliable people in general that we believe what they say, even though you said that didn't happen anymore. So,
assuming the defendant could rely on some other provision, which we don't believe he can.
No.
But the Sixth Amendment right to counsel, it doesn't create additional rights. What it does is it evaluates counsel's performance under the circumstances as they existed at the time. Now, defendant brought up the fact that there is a right to confront witnesses at suppression hearings and at sentencing hearings and at parole revocation hearings. That's a procedural right to cross-examination. It's not a Sixth Amendment right to confrontation. We know from Crawford versus Washington, the Sixth Amendment right means that the state cannot rely on hearsay evidence that a defendant has not had a prior opportunity to cross-examine. And so it's the Sixth Amendment right that prevents the state from relying on hearsay. That's completely different from saying the defendant has the right to be able to cross-examine any witnesses that the state calls. And in fact, at a preliminary hearing, the defendant will have the right to cross-examine. I think we're planning on calling 4 witnesses. Defendant will have a right to cross-examine those witnesses.
Why is this a
But a
week?
procedural right to cross-examination doesn't mean that the Sixth Amendment right, as interpreted in Crawford, applies and precludes the reliance on hearsay. With respect to due process and the 14th Amendment, again, you have to look at what process is due under the circumstances. And here, again, we've got a very low standard. And the state's process here gives the defendant far more protections than the federal grand jury proceeding does. Both of them determine probable cause as to whether the defendant can go to trial. And so due process doesn't supply some sort of right to confrontation that the Sixth Amendment right doesn't supply. The equal protection argument is interesting because defendant has not shown that he's similarly situated. Well, let me back up. What defendant relies on is Morrissey versus Brewer, which is the case that says defendants have a right to confront and cross-examine witnesses at a parole revocation hearing. But that's a defendant who has been convicted at trial and who is facing reimposition of a criminal sentence to serve out the remainder of his sentence. Defendant here isn't similarly situated to that type of a defendant. So he can't make an equal protection challenge based on that situation. And again, Morrissey versus Brewer does not say that the Sixth Amendment right to confrontation applies. It merely says as a matter of due process, if the state is calling the witness, the defendant has the right to cross-examine them at the proceeding, just like the defendant does at this preliminary hearing. As far as the Eighth Amendment goes, the state doesn't have any qualms with the idea that the Eighth Amendment, if we get to the point of whether or not the death penalty is an appropriate penalty here, certainly the Eighth Amendment heightened protections apply there. But we're not at that point, and defendant hasn't cited any case that would extend those Eighth Amendment protections beyond the decision to impose the death penalty, or they do cite Beck versus Alabama, which talks about instructing the jury at the guilt phase. We're not at that point. You can't use the Eighth Amendment and say, well, because this is a death case, there's super due process or there's additional rules
Super due
that
process.
apply above and beyond the procedural and evidentiary rules that apply at every other stage of this proceeding. And then finally, as to separation of powers, I don't see anywhere in the federal constitution that dictates any particular separation of powers principles to the states. And so it's completely up to the state of Utah to determine how it wants to divide the powers between its various branches of government. And the constitutional provision that's at issue here clearly says that that reliable hearsay can be defined as by statute or by rule. So the Constitution itself is giving the legislature and the courts the ability to define what constitutes reliable hearsay. As far as Your Honor's question about what the state would like you to review as far as the exhibits go, we just renew our request that the court review all of the exhibits in preparation for the preliminary hearing. Thank you, Mr. Bradley. Any other questions?
No, thank you.
Uh-huh. I shop. Mommy, it's better.
They had issues.
Court, I've circled the exhibits we're asking the court to review. They are exhibits 11, 16, 30, 31, 32, 33, and 34. I have a copy for the court with those highlighted if the court
Thank you,
would
Mr.
like
Burt.
it.
Yes, and if
May
you'd
I?
like to approach, you may. I appreciate it. All right. Thank you to both parties.
And Judge, could I just briefly respond
Of
to the
course.
arguments that were made by the state? Just quickly to run through them. The state emphasizes there's a low burden at the prelim. Granted, it's a low burden, but as the State versus Virgin, VIRGIN case said, low burden does not mean no burden. And the U.S. Supreme Court in Coleman versus Alabama recognized that the burden of proof at the prelim is very low. They nevertheless held that the defendant has a Sixth Amendment right to the effective assistance of counsel. So the fact that it's a low burden does not govern whether procedural rights should be applied. And the Coleman case holds exactly that. The state says that the degree of reliability depends on the nature of the proceedings. That's true. But this is a case where the state of Utah has provided procedural rights at the preliminary hearing, unlike grand jury proceedings. There are rights granted by statute to counsel. There's constitutional right to counsel. There is a right by statute to call defense witnesses, to subpoena witnesses. So the court has to take those procedural indicia into account in determining what other rights might be applicable. And both the U.S. Supreme Court and the Utah Supreme Court has said that the preliminary hearing is a critical stage of the proceedings. The state says that, citing this Ninth Circuit brief opinion, the Peterson case, that it's illogical that the preliminary hearing must have greater protection than grand jury proceedings. It might be illogical, but the reality is that defendants are accorded greater rights in preliminary hearings than at grand jury proceedings. There is no right to counsel at grand jury proceedings. There is no right to subpoena defense witnesses at a grand jury proceeding. And yet in Utah, as elsewhere, defendants do enjoy those rights to certain protections. And once having defined that it's an adversary critical proceeding, the state has an obligation to provide the tools necessary to make that confrontation meaningful. The state emphasizes that the defense has a right to call witnesses. Theoretically true, but irrelevant in this case because, as the court will see from reviewing the exhibits, how the state proposes to make its case in this case is exclusively through the use of hearsay. So calling a record custodian or a police officer who has no knowledge about the essential elements of the offense, the defense could cross-examine that person on some chain of custody issues, but it's got nothing to do with the critical issues before the court, which are the essential elements shown by probable cause. And in this case, those elements are going to be satisfied by hearsay alone. The defense says that, or the state says that there's no equal protection problem here because we're not similarly situated to probation or parole violators. In all three of those cases, the interest at stake is whether the defendant should be confined for prolonged periods of time pending the outcome of his hearing. So a parole revocation hearing, especially the preliminary parole revocation hearing, is very, in fact, it's indistinguishable from a preliminary hearing. The goal is the same, to determine whether there's cause to hold the person, deprive that person of liberty pending further proceedings. So there is an equal protection violation here. The state says that the court can only look to the Sixth Amendment. As I understand the argument, the court cannot look to procedural due process.
What?
Just a quick question. So apparently it's a violation to keep him locked up. So let me ask you, even though I'm wrong, just bear with me a sec. So if they go and say First Amendment, but like he's locked up or anything, what happens if they let him go out and he's got like a monitor or saying house arrest or whatever? I mean, don't they have any common sense about people out there who may take a instant remedy to the problem because of what he has done? There are people out there who are just wishing. So unless I've misunderstood that, is he trying to say, oh yeah, put him out into freedom, put house arrest or whatever, right? And then basically exactly, sweetheart.
I have to go check my house. I think we had a power outage real quick, and all my stuff is in a battery backup, and I hear something beeping, and I want to know what it is. So
Okay.
I'm gonna restart this, but this I'm tuning out now because he just likes to hear himself talk.
Yeah, he can rock. In the Menendez case, you had some of these hearings that was 3 hours long outside the president's jury.
And I'm pretty sure he's the reason.
Yeah. Go and do your checks. Squid.
It's guaranteed by the 14th Amendment. It cannot look to equal protection. It cannot look to the 8th Amendment. It cannot look to any other doctrines beside the 6th Amendment to determine confrontation. And we've pointed to the court a long line of cases in both the U.S. Supreme Court and the Utah Supreme Court, which refute that contention. It's clear the court has an obligation to look at whatever constitutional provisions are implicated by the procedure in question. And the Utah Supreme Court, when it was looking at that subpoena powers case, looked at whether the act violated confrontation rights, equal protection, separation of powers. No one ever suggested that the court had no power to look at various constitutional theories. That theory is not supported by the case law. And then lastly, the state says that we've cited no cases to the court saying that the 8th Amendment applies to the preliminary hearing procedure of this case. And that's simply not true. Gregg versus Georgia said that every procedural protection must be observed in a capital case, not in a capital trial, in a capital case. And as charged right now, this is a capital case. And we've also cited to the court the Ford case, Ford versus Wainwright, also along the same lines, saying that in capital proceedings, there's a heightened need for reliability. And then lastly, in our reply, we cited a whole string of state court cases, which hold that at the preliminary hearing, not the trial, the preliminary hearing, the court has an obligation to employ a heightened standard of reliability. Thank you.
So for a non-American to understand this, the 8th Amendment from the United States Constitution states, which is part of the Bill of Rights, explicitly prohibits the federal government from exposing excessive bail, excessive fines, or cruel and unusual punishment. Right.
In this case, the cruel and unusual would be the death penalty.
Yeah. Right. The guy is on trial for a specific reason. Right. He should be held in a cell, preferably away from anyone who can, but I'm looking at excessive fines clause, excessive bail clause. I mean, what is he trying to do? Is he trying to get his client back on the street?
No, I think. Well, I'm not.
I'm sorry
exactly,
if I misunderstand this. But...
No, I'm not exactly sure what their whole thing is anymore. Like,
Yeah,
it's
me
all
neither.
convoluted.
Michael Burke kind of off me.
Yeah, I'm not gonna lie. All the other attorneys I kept up with, even though I don't like Novak, I can at least understand, and I can at least understand what he's trying to say because he says it in a way that I understand. This guy is talking about 10 to 15 minutes longer than necessary.
Yeah, that's
to say something that even Novak would have said in like 5 minutes.
He does that, and this shows how this judge is impatient because the Menendez judge was not patient. That judge was very.
Do you know that, like, under this unusual punishment clause, you've also got prison conditions? This clause is also used to challenge substandard conditions in correctional facilities, such as a denial of basic medical care, overcrowding, or extreme. So why don't you just stick him in a fucking 5-star hotel? I mean,
they don't call it 3 hots and a cot for a reason.
Yeah, I mean, like, it's like, what?
And that's part of the reason that people keep going back. I'm convinced is when they get out, we have a very poor system of how to help people when they get out of prison or jail for any number of reasons. And then they don't know anything else. So what do? They reoffend because they don't know anything else. They don't know. They know that at least in prison, they'll get a warm bed and 3 meals a day. Whereas on the outside, they may not. So.
And this dude is most likely never getting bail until till he's either acquitted till he's either acquitted, because if he convicted, of course he's not getting out. But only way he's getting out is probably till he's acquitted, because I always say I think the guy in Texas is going to ruin bail for people. There's a guy in Texas who was out on bail. Dude decides to cut off his ankle monitor and flee to Italy.
I mean, like, as far as I'm concerned, if I was sitting there and they were going on, oh, well, you put him on bail or whatever, I'd be going, okay, his bond is 2.6 million. I would not allow him back into the populace, because 1, there could be someone out there just waiting for that moment. 2, he could be a danger to society because, look what he's done. And 3, right, you're basically letting him get the opportunity to leave the country, regardless if you've got a monitor or not, right? I mean, I'm pleading the fifth.
Stop.
Not funny.
Thank you. The Chase, does the state oppose defendant's request on docket 593?
And there is also the scheduling of the responses to an EMC request, which we discussed.
Okay, well,
need
thank you
to
for
deal with that
reminding
as
that. Thank you, Mr. Novak.
That media crap. Now they have already filed the request to film. They filed that on Friday.
Basically a motion to begin the process of compelling, of getting a subpoena for an out-of-state witness.
Yes.
Here's the issue is, we know that from the pleading that the out-of-state witness's attorney has declined to accept service for their client.
And that's his roommate.
This witness has appeared by 1102.
They're talking
We
about-
believe that that's appropriate and satisfies probable cause. The rule requires defense counsel to certify that this witness is necessary and material to the probable cause determination. Under State v. Lopez, we don't believe it is. We got this at 8:03 last night. I looked at it for the first time just moments ago. What I'd really like to do is have a couple of days to respond to this. I know time is of the essence, but that's where we're at. So I really don't want to respond right now. If I did, I'd probably submit.
Their response came on
Thank
the
you. To
17th.
defense, is there any additional briefing needed in addition to what you've submitted on docket 593? And so I'm just seeing if there is, trying to create an expedited.
Only to respond expeditiously to whatever the state files. So for example, and again, we're both going off the fly. I'm now responding to Mr. McBride's statement. This is not a Lopez situation. The witness is not the victim. As Your Honor knows. So it's not a Lopez situation. It's a question of whether the witness is a material witness. So I think to squarely answer the court's question, we need a very short period of time after the state responds, and if the witness's counsel wants to respond, to file, I guess, what we would call a reply. But we are moving, we can move as quickly as the court requires.
Thank you.
Yeah.
To the state, how much time, and again, I realize that this is appeared on the horizon.
I think this is just more arguing.
All right, so we're looking at Tuesday, the 16th of June.
Yep. So I'm
Close
gonna
of business.
stop playing this because they don't really talk about
Yeah,
anything.
that's pretty much it for that.
Yeah, they have 10 more minutes of scheduling and
Yeah.
this and that, nothing actually worthwhile. So we are going to stop sharing that.
The East Idaho news link for today, if you're playing that, started the 54-minute mark.
54 minutes. Do-do-do-do-do-do-do-do-do.
Probably with the other feeds. So East Idaho news is the one that started actually on time.
Okay.
Don't
I
sound
have
like-
to go into the East Idaho news. Okay.
And the fact that they dropped
Hold
the
on.
document, the fact that they dropped the document on these guys, and he stood up and he went, "Hey, what about this document we just got? We haven't even had a chance to read it yet." I mean, talk about. And then he stood there, pulling crap out of his ass, trying to come up with some sort of excuse. But no.
Well, the state hadn't had the opportunity to read it because they had to prepare for that, and they was filed like what do you say, like 9 o'clock that night previous.
Yeah, he said he was in the office at 8 o'clock that night, and it wasn't filed yet. This is one of the interesting things. Like my lawyer was like, he's like, I have 3 kids and a wife. I don't have time for friends. I'm here all the time. And I was like, I don't know when's the best time to email you something. He's like, I am here all the time. I have no friends.
As long as you don't do like what Sarah Boone did, call like all sorts of weird hours of the night. 2 o'clock in the
Wait a
morning.
minute. Wait a minute. If he didn't have any friends, how the hell does he have 3 kids?
Well, his wife.
Well, wouldn't she be a friend first and then?
Well, you know what I mean.
Yes, I'm being technical and I'm being a bit, yeah. Don't
Being a
even say it.
pain in my
Don't even,
butt.
yeah, but. I like big butts, but I tend to too. I blame Flashfan on that one. Your Honor, objection.
On that note, we are going to start this. This was from today.
Yeah, this is his rulings on those 2 motions that were just argued.
Wait, what's this one?
This is the hearing from today?
Yeah, the judge is going to rule on the two things that was argued about that we just watched. He's going to rule on those.
Yep. This was streamed 5 hours ago. Maybe.
I thought he came.
Yeah.
Oh, there you go.
Robinson. Counsel.
Jeff?
Oh my God.
Great.
Yeah, she looks like she had her face
Michael
slapped.
Burt here on behalf of Mr. Robinson, and if maybe we could just check and make sure he can hear us.
There's good old
Mr. Robinson, can you hear us? All right. Good morning to you all. All right. I apologize for the slight delay. There was a couple of last minute things I needed to do as it relates to this case. So I appreciate your patience. I know your time's important, and the court respects that. And before we begin, counsel for the state, could you provide a brief status update regarding discovery?
Yes, Judge, I'll ask Ryan McCray to do that for the state.
See, more discovery.
I think it was just late last week, we provided 12 additional files. I think that's a duplicate share. That was reports from the ATF labs. That brings our total back up to approximately 100% of what we have has been shared.
All right, thank you. All right, and anything, does the defense need the benefit of the record as it relates to that issue?
No, Your Honor.
All right. Turning to defense's motion for order to show cause.
We go.
The party submitted additional briefing on June 17th and June 18th, with the most recent filing being received at approximately 9:21 on June 18th. The court intends to consider all briefing and arguments submitted by the parties before rendering its decision in the interest of justice and to ensure the constitutional rights of all parties upheld. Because the most recent submissions were filed shortly before the anticipated ruling, the court requires additional time to complete its thorough review. The court recognizes the importance of the issues presented and will issue its decision on a schedule that will be announced at the conclusion of today's proceedings on the remaining matters. And those remaining matters are the defendant's motion in limine to preclude the utilization of Article 1, Section 12 of the Utah Constitution and Rule 1102 of the Utah Rules of Evidence to sanction the admissibility of hearsay evidence to establish probable cause at the preliminary hearing and defendant's application for certification for attendance of an out-of-state witness and state's motion to quash subpoenas. And so the court will issue its ruling first on its motion in limine. And I'll be reading from the order that I intend to upload on the docket later today. In his motion in limine to preclude the utilization of Article 1, Section 12 of the Utah Constitution and Rule 1102 of the Utah Rules of Evidence, defendant Tyler James Robinson seeks an order preventing the state of Utah from relying on hearsay to establish probable cause at his upcoming preliminary hearing. The motion was fully briefed. The court heard oral arguments on June 12, 2026. Now, being fully advised of the premises and relevant legal authorities, the court hereby respectfully denies the defendant's motion for the reasons set forth below.
Okay.
In Utah, the primary purpose of the preliminary hearing is limited to determining whether probable cause exists. And counsel, as I have done in the past, I will omit the citations, and that will be in the full order that's uploaded. Although the preliminary hearing is a critical stage of the criminal process, it is not a trial and does not involve a determination of guilt or innocence. And let's see, I'm sorry, I lost my place.
I was wondering what was going on here.
Reading too fast.
The court does not understand this principle to mean that constitutional protections are categorically inapplicable at a preliminary hearing, rather because a preliminary hearing serves the limited purposes of determining whether probable cause exists. The scope and operation of a particular constitutional protections must be evaluated in light of that purpose. Accordingly, the court addresses defendant's constitutional arguments individually while recognizing that the procedural safeguards required at a probable cause determination need not mirror those required at trial. Defendant raises several constitutional objections to that conclusion. Defendant argues that permitting the state to establish probable cause through hearsay evidence violates his rights under the 4th, 6th, 8th, and 14th Amendments to the United States Constitution, as well as separation of powers principles. Of the constitutional rights defendant seeks to fully invoke at the preliminary hearing, Utah courts have directly addressed the application of only one, the right to confrontation. The court recognizes that defendant's constitutional concerns are substantial and warrant careful consideration. Nevertheless, the court's analysis is guided by a limited function of the preliminary hearing and the governing precedent interpreted in Article 1, Section 12. In State v. Timmerman, the Utah Supreme Court determined that full application of a defendant's right to confrontation is necessary at trial, but not at the preliminary hearing. The Timmerman court reached this conclusion after comparing the different purposes of the two proceedings. That court recognized under the amended language of Article 1, Section 12 of Utah's Constitution, a defendant at a preliminary hearing faces only a probable cause determination that is subject to a significantly lower burden of proof, whereas at trial, that same defendant faces a determination of his guilt or innocence that must be established beyond a reasonable doubt. Considering the distinction between the issues and the purposes of the two proceedings, the Timmerman Court believed a relaxed application of the defendant's constitutional right to confrontation at the preliminary hearing was entirely appropriate. Although Utah courts have not addressed what is the appropriate application of other constitutional rights at a preliminary hearing, this court follows the Timmerman Court's reasoning in concluding that a relaxed application of defendant's constitutional rights at the upcoming preliminary hearing is likewise appropriate because of the limited purpose of the proceeding. For example, defendant argues that permitting the state to rely on hearsay evidence, reliable hearsay evidence, deprives him of his Sixth Amendment right to effective counsel before it prevents his counsel from utilizing all the tools of effective advocacy, namely the right to cross-examine any hearsay declarants. Defendant's arguments rest on the premise that effective assistance of counsel requires access to the full range of adversarial tools, including cross-examination at every stage of the criminal proceeding. The court is not persuaded by defendant's argument. The full application of a defendant's right to counsel at a preliminary hearing, which is limited to a probable cause determination, need not be as exhaustive
He's
as it
so
must be
nice
at
with it.
trial. The right to
Sorry.
counsel may be tailored to the proceeding
Did you
at
see
hand.
that?
The same can be said for the protection.
Sorry, look at this face. Look at this. We got to back it up. He's writing.
Defendant's argument. The full application of a defendant's right to counsel at a preliminary hearing, which is limited to a probable cause determination, need not be as exhaustive as it must be at trial. The right to counsel may be tailored to the proceeding at hand. The same can be said for the protections under the 14th Amendment's due process clause. At minimum, due process requires notice and an opportunity to be heard in a meaningful manner.
Yeah.
I've noticed something. Right. Who on there, are they all the same from the, are they all part of the same team for the defendant?
No. This is everybody.
Yeah,
Some people have their cameras on and some people don't. I think that I can't remember. I think this guy is a prosecutor.
Right, because I found it very interesting because if you go back a little bit, which I don't want you to do, the guy below fucking smiley face, right? He was texting something on his phone, and then when he put it down, the guy up there with the Mr. Smiler, right? He looked down. The guy, prosecutor, he looked down, and then she looked down, and they all were looking down at the same time. And then at one point, they all started looking up at the same time, except the old guy in the middle. He didn't have his glasses on, so he was struggling to read whatever message he got.
He probably not an iPhone user.
Probably no. But that's one thing I noticed. That guy there in the black suit with the white pin on it, him.
I know that these two with the cameras off on the right side are prosecutors, but I know that I think this guy over here on the left is a prosecutor as well.
And then in the Utah County Jail, that's Robinson. He never had his camera on for.
Yeah, he doesn't have to. So, just interesting. I don't know who she is. She might be another member of their legal staff.
Yeah, but he did something on his phone, and then suddenly they all looked down.
Now I think there is another attorney who was added, another prosecutor who might with a foul. Can't remember what motion was, but it's out recently, and it was a different attorney whose name I don't recognize.
I'm at 102.50. Angel, I'm at 102.50. Just remember that. So Chad Grunauer is a prosecutor. Attorney Stacy Visser, I think she's the defense. She's the defense. So that's who that is. I recognized her name. I just had never seen her face.
Yeah, Chad Grunander is the lead prosecutor.
Yeah, Grunander, Ballard, and McBride are prosecutors. Then Visser, Nestor, Burt, and maybe Gray.
No, Gray.
No, Jeff Gray's
county attorney.
County attorney. That's who's on the right side. So it's because here skip forward. So that's Stacy Nesser. I have to. It's like I recognize these people's names. I just can't rarely put faces with names except for Kathy Nestor and Michael Burt. So, yeah, that's Jeff Gray. He's the county attorney. Now that I see his face, he testified in that hearing we just watched.
Yep.
I just had to. I don't know what I was thinking. He looks different on camera. He looks older in this. He looks older on camera than he did in the hearing, doesn't he? Like the bags under his eyes are just bigger today.
I mean, he is the county attorney, so he prosecutes all cases in that jurisdiction. So
that's true. Oh, Flashfan, did I send you the article about the district attorney here and people jockeying to get his position before he was even cold?
Oh man, that's.
Oh yeah. I want to read it, but I also don't want to piss off the fact that I live down the street from the sheriff, and I don't want to piss off the sheriff.
Freedom of speech, freedom of expression.
Yeah, but I do live in a good old boys section of the country.
Oh well, you just go up to him, kick him in the old ghoulies, make his man sausage go from his between the legs to his forehead.
Which is one of the reasons that I liked my friend, and not a lot of other people in law enforcement did.
And that Nestor woman, she looks like she didn't get laid last night.
She hasn't probably gotten laid since I was born.
Oh shoot!
What is that old lady or the young one who looks?
Nestor was Corey Richins' attorney. Corey Richins was the woman that was found guilty of unaliving her husband and then writing a children's book about it.
Nestor is she's somewhat older. Yeah, because she's been an attorney since the 90s. So.
Yeah, but I bet you any money
awful.
he put a couple of glass shots in there, she'll be freaking up and down that pole dance, that freaking pole like a freaking toll.
We're still here. I forgot about this nurse left. Yes, we are still here. 2 hours in. We are watching the hearing from this morning.
Yep.
So, yeah. So,
Sorry, I'm just, I note some things that I need to.
He lost his place.
So I'm making those changes right now. However, depend upon the nature and purpose of the proceeding at issue. Because a preliminary hearing is limited to determining probable cause rather than guilt or innocence, due process does not necessarily require all the evidentiary safeguards applicable at trial. The court is likewise unpersuaded that the Eighth Amendment is implicated by the challenged procedures. The Eighth Amendment authorities cited by defendant concern the reliability required in the proceedings that determine guilt or authorize punishment, particularly capital punishment. A preliminary hearing performs neither function. It serves only to determine whether probable cause exists to believe the charged offenses were committed. Because defendant's guilt, innocence, and punishment are not at issue during the preliminary hearing, the court concludes the Eighth Amendment concerns identified by defendant are not implicated at this stage of the proceedings.
See? It's a preliminary hearing.
But Article 1, Section 12 of the Utah Constitution and Rule 1102,
and
the Utah Rules of Evidence create an unconstitutional mandatory presumption.
I just can't get over it. This is what makes me think that they were strictly trying to delay stuff. This is a preliminary hearing. It's not anything other than saying guilt or guilty, or are you pleading guilty or not guilty? And it's going to take 4 days.
Yeah, that comes up to I don't know why they're long. The state said they got 4 witnesses. I'm like, why do you need 4 days for that? I don't know.
It's just, it's like, it's the whole point of a preliminary hearing is just to see if there's enough evidence to bind you over for trial. The fact that this has been going on for 9 months and we still don't even have a plea is like, makes me think that they're just trying to drag this out as long as possible.
And people did say that like the judge, he's a good judge, but he's newish, so they say
he's letting the attorneys who have been attorneys for many years push his ass around. Sounds like somebody else I know, Belatho. Doesn't that sound like Belatho? Not a bad judge in general, but just lets people push him around because he's scared of like messing up the status quo
or appeals or whatever. We make sure everything.
He needs.
But the thing is, you always have to remember, the ones that don't growl are the worst biters.
True. However,
Kind of like Squid's favorite judge in Waukesha, Wisconsin. Is she even still a judge?
God, I hope not. Probably. She tried to run for Wisconsin Supreme Court and lost in a blaze of epic proportions. So we're going to finish this. We got about 20 minutes left, and then I got to go to work. So if we don't, we kind of see what the judge is doing. So we're not going to get to his scheduling stuff at the end. When he starts talking about that, he's going to go. But I am speeding it up because this judge talks slow as hell, too.
Yeah, I'll look and see if they got a hearing scheduled for this week or something like that, and then I'll message you about it if they do.
Okay.
Of reliability and results in inappropriate burden shifting, the court does not find this argument persuasive. The presumption of reliability is confined to the presumption that the hearsay evidence is admissible. That the presumption does not require the magistrate to find the evidence credible or that it supports a finding of probable
confused.
cause. The magistrate still retains the ultimate decision-making authority on whether probable cause has been established. Admissibility and evidentiary weight remain distinct concepts. Although Article 1, Section 12, and Rule 1102 permit the admission of reliable hearsay, they do not require the magistrate to accept that evidence as credible or sufficient to establish a probable cause. And as probable cause determination remains in the hands of a magistrate, a judicial officer, Article 1, Section 12, and Rule 1102 have not violated the separation of powers principles. Based off the foregoing analysis and findings, the court issues the following order. Having carefully considered defendant's constitutional objections, the governing provisions of Article 1, Section 12 of the Utah Constitution and Rule 1102, and the applicable authorities, the court concludes that the challenge provisions may constitutionally be applied at defendant's preliminary hearing. Accordingly, defendant's motion is respectfully denied. And that concludes the order as it relates to reliable hearsay in 1102. Court now turns to the second ruling, order regarding defendant's application for a certificate of attendance of out-of-state witness in state's motion to quash subpoena.
Oh, that's the last tweet.
Give me one moment here. I just need to kind of drink of water.
Huh?
That's
Again,
the
I will omit
roommate
the citations, but it will be included in the full order that is uploaded with the court. This matter comes before the court on defendant Tyler James Robinson's application for certificate of attendance of out-of-state witness under Utah Code, Section 77-21-3. Defendant seeks to compel the live testimony of Lance Twiggs at the upcoming preliminary hearing. The state opposes the application and seeks to quash the subpoena. Having reviewed the briefing and the pertinent legal authorities, the court issues the following decision and order. Defendant is charged with aggravated murder, felony discharge of a firearm, obstruction of justice, tampering with a witness, and violent offense committed in the presence of a child. Lance Twiggs allegedly resided with and was in a romantic relationship with defendant at the time of the alleged offenses. The state does not intend to call Mr. Twiggs to testify live at the preliminary hearing. Instead, the state plans to establish probable cause through reliable hearsay, specifically a video recorded interview of Mr. Twiggs conducted pursuant to Utah Rule of Evidence 1102. The state will also rely on electronic messages, a handwritten note, and other corroborating evidence. According to the record before the court, Mr. Twiggs allegedly made statements to investigators indicating that the defendant confessed to the crimes, concealed the weapon, disposed of clothing, and directed Mr. Twiggs not to contact law enforcement. Defendant seeks to compel Mr. Twiggs' attendance from Texas to provide live testimony. Defendant asserts that he intends to cross-examine Mr. Twiggs extensively concerning the reliability and credibility of his statements, his immunity agreements with the state and federal prosecutors, his state of mind, and the surrounding circumstances of the alleged offenses.
Answer.
Due to the fact that obviously with the high profile with the president and Mrs. Kirk, and everything else, will there be a possibility that there could be some involvement from a political party?
No,
Okay, good answer. Thank you.
because he's just a civilian at the end of the day.
Now, the side might the defense probably will try to make this political, but as far as like it being a part of the case, I doubt it.
I mean, I believe it was politically motivated. However, that doesn't mean politicians will get involved other than making statements like they already have.
Yeah.
So
When Mr. Twiggs' counsel declined to accept service of a subpoena, defendant sought this court's intervention to certify the out-of-state subpoena. The preliminary hearing is a fundamental procedural right under Article 1, Section 13 of the Utah Constitution. Its purpose is strictly limited to determining whether probable cause exists to bind a defendant over for trial. To prevail, the state must present sufficient evidence to support a reasonable belief that an offense has been committed and that the defendant committed it. Under Rule 7b of the Utah Rules of Criminal Procedure, the probable cause determination may be based in whole or in part on reliable hearsay. While Rule 7ba states that a defendant may call witnesses and cross-examine adverse witnesses, the right to subpoena witnesses is not absolute. Under Rule 14a2, the court may quash or modify the subpoena if compliance would be unreasonable. The Utah Supreme Court has repeatedly emphasized that a preliminary hearing is not a trial on the merits, but a gateway to the finder of fact. Consequently, the magistrate's role is not to weigh credible but conflicting evidence, nor to eliminate alternative inferences favoring the defense. Such tasks are reserved for the jury at trial.
A magistrate may only disregard evidence if it is wholly lacking and incapable of creating a reasonable inference. Recently, in State v. Lopez, the Utah Supreme Court clarified the intersection between a defendant's right to call witnesses at a preliminary hearing and the court's authority to quash subpoenas. The court held that a subpoena compelling an alleged victim to testify at a preliminary hearing is unreasonable and should be quashed unless defendant demonstrates the subpoena is necessary to present specific evidence that is reasonably likely to defeat the showing of probable cause. Defendant argues that he has a constitutional right to compulsory process under the Sixth Amendment in Article 1, Section 12 of the Utah Constitution, as well as a right to call witnesses under Rule 7b. Defendant contends that Mr. Twiggs is central, highly material witness whose testimony touches on nearly every charge and enhancement. Defense counsel argues that Lopez was specifically tailored to protect the constitutional rights of victims pursuant to the Victims' Rights Amendment, and because Mr. Twiggs is not a victim, Lopez does not directly apply. Defendant asserts that he must be permitted to test Mr. Twiggs' credibility, the circumstances of his immunity, and the reliability of his statement through live cross-examination. The state opposes the certification and moves to quash the subpoena. The state argues that the preliminary hearing are no longer discovery devices, having been strictly limited to probable cause determinations. Furthermore, the state argues that the Utah Constitution expressly permits the use of reliable hearsay at preliminary hearings, a practice which would be eviscerated if defendants could routinely subpoena the hearsay defendants. The state relies on State v. Schmidt and State v. Robinson to assert that credibility weighing at this stage is extremely limited, rendering defendant's stated goal of testing credibility immaterial to the probable cause analysis. Thus, the state argues the subpoena is unreasonable under Rule 14a(2). The court expresses no opinion regarding whether the state ultimately will establish probable cause. The court addresses only whether the subpoena should be enforced based upon the parties' current proffers. The proffered evidence, including statements that the defendant confessed to shooting, hid a rifle, changed clothing, and directed Twiggs to withhold information, is directly material to the elements of aggravated murder, obstruction of justice, and witness tampering. If this evidence is presented at the hearing and evaluated under the governing preliminary hearing standard, which requires the court to view it in the light most favorable to the prosecution, as required by State v. Schmidt, it would constitute evidence from which a magistrate could find probable cause if credited under the standards governing preliminary hearings. A central dispute is whether the standard established in State v. Lopez applies to Mr. Twiggs, who is a non-victim witness. Defendant correctly argues that Lopez arose in the context of a subpoena directed to an alleged victim and that the Utah Supreme Court's analysis was informed in part by the protections afforded under the Utah Victims' Rights Amendment. The court agrees that Lopez cannot be read without attention to that context. Victim status matters in Lopez because the subpoena imposed burdens upon persons whom Utah law independently protects from unnecessary harassment, delay, and re-traumatization. Although Lopez arose in the context of a victim subpoena, its discussion of Rule 14a(2) provides guidance concerning how courts evaluate reasonableness in light of the limited purpose of a preliminary hearing. The court need not decide whether Lopez's precise holdings extend to all non-victim witnesses. Even assuming it does not, the same Rule 14 reasonableness considerations identified in Lopez support denial of the requested certification under the circumstances presented here.
He's been
The
really
Lopez court
long-winded.
emphasized several principles that are not dependent upon victim status. 1, a preliminary hearing is not a discovery device. 2, the Utah Constitution permits the state to establish probable cause through reliable hearsay. And 3, the magistrate's role is limited to determining whether probable cause exists, not to resolve ordinary credibility disputes or weighing competing evidence. Those structural principles apply regardless of whether the subpoenaed witness is a victim, an eyewitness, a cooperating witness, or other hearsay declarant. Accordingly, the court relies primarily on Rule 14a(2) in the limited purpose of a preliminary hearing. The court references Lopez only because of its discussion.
Yep.
I have to apologize, but I have to take my leave.
No problem.
And I just want to say thank you very much to everyone who's supporting the squid. And unfortunately, I won't be doing the yayit, but we've got young lady who can cover me for that one.
We're going to skip ahead a little bit too. So
yeah. Flashfan, you take care, fella.
This
okay.
judge is extremely long-winded.
And
I think he's just trying to pay bills.
And I'm not far away from the big boom. Anyway, so I'll take care, everybody. Again, thank you very much. And little baby angel, bye-bye.
She knows who you're talking about when you say that. Say bye. Say bye, Spawn.
Eat.
No, not eat later. Later, you can do yeet later. But I'm going to say goodbye, sweetie, yeah? Take care, be good.
Spawn's leaving. Say bye.
Eat.
No. He's going to eat you.
I forgot how to get out. Oh, there you go.
I forgot how to get out.
Help, someone let me out. Let me out. Bye.
Bye. All right, we're gonna skip ahead a little bit because I did check the Substack to see if the ruling was in there yet, and it's not. So we have to listen. Otherwise, I would just read it for you guys, and we'd skip this part.
upon that proceeding. The court determines that compulsory process does not automatically require live testimony from a hearsay declarant at a preliminary hearing merely because a defendant seeks impeachment. Whether compulsory process requires live testimony depends upon the relationship between the proposed testimony and the probable cause determination at issue. Under the circumstances presented here, defendant has not identified testimony reasonably likely to negate probable cause, and the court therefore concludes that compulsory process does not require certification of the subpoena. For these reasons, the court need not determine whether Lopez formally governs subpoenas directed to non-victim witnesses, even assuming it does not. The Rule 14A2 reasonableness principles discussed in Lopez supports the result here. The question remains whether the defendant has demonstrated that the proposed testimony is necessary to present specific evidence reasonably likely to defeat probable cause rather than merely impeach the credibility of the state's evidence. Even under the framework discussed in Lopez, a subpoena survives a motion to quash only if the defendant demonstrates that the testimony is necessary to present specific evidence that is reasonably likely to defeat the showing of probable cause. Defendant asserts he wishes to cross-examine Mr. Twiggs on his reliability, credibility, immunity, state of mind, and the surrounding circumstances. Under Utah law, this does not establish a basis to require live testimony at a preliminary hearing.
It's not appropriate.
As established in State v. Ramirez and State v. Schmidt, the magistrate may not weigh credibility
He
but
could have.
conflicting evidence. Even if the defendant's cross-examination successfully exposes inconsistencies in
Not
Mr.
appropriate.
Twiggs' statements or highlights his motives to lie due to his immunity agreements, the magistrate is required to draw all reasonable inferences in favor of the state. Evidence demonstrating bias, motive, immunity benefits, or inconsistent statements may be highly relevant at trial and may provide fertile grounds for cross-examination before the ultimate trier of fact. The court does not minimize the significance of immunity agreements as potential sources of bias. Rather, under the governing preliminary hearing standard, such evidence affects the probable cause determination only if it eliminates the reasonable inference arising from the state's proffered evidence. However, under the limited function of a preliminary hearing, such evidence defeats probable cause only if it would render the state's evidence incapable of supporting a reasonable inference that the defendant committed the charged offenses. Absent such a showing, the court may not resolve competing credibility determinations or weigh conflicting inferences against the state. Even assuming defendant successfully elicited the anticipated impeachment evidence regarding bias, immunity, motive, or inconsistent statements, the court cannot conclude on the present record that the state's proffer would become wholly lacking or incapable of supporting a reasonable inference of probable cause under the standards governing preliminary hearings. The court recognizes impeachment evidence may, in an appropriate case, undermine probable cause where it demonstrates the state's evidence is so unreliable, internally inconsistent, or otherwise deficient that no reasonable inference supporting probable cause remains. In such circumstances, impeachment evidence may do more than merely challenge credibility. It may negate the evidentiary foundation necessary to support bindover. Defendant has not made that showing here. The anticipated examination concerns matters that would generate competing
so it
credibility
sounds like you want
inferences
to deny.
rather than eliminating the reasonable inferences
Yeah.
supporting the state's showing. Nothing in this ruling should be understood as creating a categorical prohibition against subpoenas directed to non-victim witnesses at
I
preliminary
feel like
hearings.
this
The court
could be
concludes
done
only
so
that the
much
defendant's
quicker.
present proffer does not identify testimony
You
reasonably
thought
likely
for
to negate probable cause under the circumstances presently before the court. The court also notes that the defendant seeks compulsory process through the interstate witness certification procedure, which imposes burdens upon a non-resident witness in a sister state court. While not dispositive, those considerations further inform the Rule 14 reasonableness analysis. Under the record presently before the court, the defendant has identified anticipated impeachment and credibility evidence, but has not identified specific testimony reasonably likely to negate probable cause. Given the limited purpose of the preliminary hearing and the state's ability to proceed through reliable hearsay, the court concludes that enforcement of the subpoena would be unreasonable under Rule 14A2. This ruling rests on defendant's present proffer and the record currently before the court. The court need not decide whether different circumstances, a different evidentiary showing, or a different category of witness would warrant a different result under Rule 14A2. The court's ruling is procedural rather than evidentiary. Nothing in the decision and the order should be construed as a determination regarding the credibility, reliability, weight, or ultimate admissibility of any witness, statement, or item of evidence that may be later presented. Those matters remain for determination under the governing standards applicable at the subsequent stage of the proceedings. So under findings, the preliminary hearing is limited to determining probable cause and is not a discovery device. The state is constitutionally permitted to rely on reliable hearsay to establish probable cause. The record presently before the court that the proposed examination is directed primarily toward credibility, bias, reliability, and impeachment rather than toward evidence likely to negate probable cause. Applying Rule 14A2's reasonableness requirement in light of the limited purpose of a preliminary hearing and the authorities discussed above, the defendant has failed to identify specific anticipated testimony that is reasonably likely to negate probable cause, as distinguished from anticipated impeachment that would merely create competing credibility inferences. Therefore, enforcement of the subpoena is not warranted on the present record. Based off the foregoing analysis and findings, the court issues the following order. It is hereby ordered that the defendant's application for certificate of attendance of out-of-state witness is respectfully denied, and the state's motion to quash the subpoena is granted. It is further ordered that this denial is without prejudice. And
We're
subject to renewal.
skipping to the next one.
Now I understand that there was another outstanding motion that was filed around the same time. I believe it was Thursday evening regarding the EMC, electronic media in the courtroom.
Oh my
There's
God.
a-
Relying on its previous arguments with respect to the media's presence and the openness of this proceeding. Again, we encourage an open and transparent process that the citizens can follow, and so they can trust the process. So we do not anticipate filing a written response to that, and we'll rely on our prior arguments and submit it to
Any
the court.
powerful preliminary
All
hearing
right,
access.
does the defense want to be heard on that issue?
Your Honor, we filed our objection yesterday, so that is before the court.
All right. Well, what I hope to do is issue a ruling on that, as well as the order to show cause issue. And again, I mean, the parties,
So he's not
namely
gonna
the
rule
defendant,
yet?
is entitled to that ruling before the hearing in order to properly prepare. And the court respects the time necessary to prepare from both sides and wishes to issue a timely order. Let's see if we can find a hearing date between now and the prelim. And again, in regards to the order to show cause, just to help give some guidance, the court prioritized the motions that would affect the preliminary hearing. Not to say that the order to show cause
It
isn't
would have to
important,
be
but that
either
does
this
not weigh
week or next
upon
week, because the
issues that
preliminary is on the 6th.
Yeah, it's we're running out of time here, sir.
It will have to be pretty quick because this thing starts on July 6th. It's not that far away. It's July 22nd. I mean, June 22nd.
Running out of time.
could result in a delay of the preliminary hearing. So I just wanted to offer that background.
Another delay.
In regards to the delay of that ruling. All right. Let's see. Today is the 22nd, and how quickly this month is passing. Let's see.
Don't care.
Date, but availability of the parties' operation on a ruling on both of these issues, the order to show cause and the motion filed yesterday.
The date is available, Your Honor.
All right. And so I see Ms. Visser nodding her head. Ms.
Yes,
Nestor?
the defense, I'm sorry, I was trying to unmute. I was having trouble unmuting.
Shocker.
The defense will be available, Your Honor.
All right. So June 26th at 8:30 in the morning. And the court anticipates starting promptly. Again, I apologize for today. There's always last minute edits that one has to make. I'd rather be concise and on point than come in not exactly where I want to be. All right, so we'll plan on June 26th at 8:30 in the morning. And that leaves one last issue. And the court wants to put all parties on notice and because this preliminary hearing will be open to the public, that the court is not allowing any electronics into the courtroom, not laptops, electronic devices, electronic watches, electronic Google glasses or Android glasses.
Friday at
however you want to
11:30 a.m.
It is
Same
the
time
court
as you.
is stating that for only the preliminary hearing, that any and all electronic devices must be left outside the courtroom, not just in your pocket. So no cell phones, laptops, tablets, electronic watches, any electronic recording device or electronic glasses will not be permitted at the courtroom. And if you have it, you will be turned away. And the reason for that is the court wishes to uphold the dignity and the civility and uphold the constitutional rights of all parties in this courtroom. And that is the best way the court sees to be able to do so. There will be a unique seating arrangement at the preliminary hearing to accommodate as much as the press and public that can be safely admitted and for an orderly courtroom. And the court will advise all the parties as we begin those proceedings on what's in the decorum order, highlighting a few points, because all parties are entitled to be treated with dignity and respect within. This does not apply to communication, and your reliance excluded obviously is counsel on record for the parties
over and over again.
Court staff.
And
so I just wanted to.
I mean,
I wish he would
understand. It's the defense that's crying about the media. Like, yeah, we understand, Your Honor. Only thing they messed up was that one time, and after that was it.
And I really wish he would go, I have a standing decorum order. It's the same as it was last time. I wish he wouldn't describe his freaking decorum order, because everybody knows his damn decorum order right now. I could probably recite that bitch in my sleep.
Yeah, most judges be like, the court signed the decorum order. That order still stands. Anything else?
Does anybody have any proposed changes to my decorum order?
Yeah.
No. Decorum order stands just the same as it has for the past 7 months. I feel like he talks about this damn decorum order, and I get it, but like there are easier ways to do it.
That's Utah. They
well ahead of the prelim, so there's no
Utah,
questions or
Idaho,
concerns that may arise.
Colorado.
I just feel like you could take a page out of like any other state's playbook where they're like, yeah, here's the problem, here's our
I
solution.
guarantee you, in California, they ruled it by, all right, the motion is denied. That's the court's order. Do anybody have any objection or anything else you want to be heard on? Nope. All right, cool.
Yeah, we're trapped in a endless circle. However, we only have 6 minutes left, so we are going to get through this because your girl's got to go to work.
Counsel, with that, is there anything else that this court can address today? And Mr. Burt, your mic is muted.
Duh. Boomer.
Yeah, definitely.
All right, give it a try.
How's that?
That's perfect. I do.
One logistical issue I'd like to raise with the court, if I might.
Yes.
As the court might be aware, we have arranged to bring to the hearing 7 forensic witnesses. The state has identified a number of hearsay reports.
Oh, they're going to
I
call.
think they're exhibits 30 through 34 that they intend to introduce. And we in turn have arranged with the federal
Now I know
authorities
why this is going to be.
fly out from the East Coast, 6 of those forensic examiners, and then we have a 7th examiner who resides in state. And in light of the court's ruling, I'm wondering if the court, and no, the state has been kept abreast of our attempts to subpoena these people. No objection to that testimony has been lodged so far by the state, but in light of the court's rulings today, I anticipate that there will be objections to the admissibility of those 7 forensic experts. And what I think would be in the interest of everybody, including the court's schedule, is if we could resolve the issue of whether those witnesses are going to be permitted either before the preliminary hearing or at the very latest after the state presents its prima facie case, because we will have those people ready to fly out. And if we can get a ruling from the court before that actually happens, we could perhaps shorten the hearing considerably and also alleviate the expense and inconvenience of flying 6 people from the East Coast. I have not had time to discuss this with the state. I know the state had not heard the court's ruling until this morning.
Like the Moyer cat from a couple of years ago
could take up either on Friday or at some date before the preliminary hearing any objections the state might have to calling those 7 forensic experts.
All right. I appreciate you bringing that up, and to all parties, anything that we can bring up prior to the prelim serves us well in regards to time management. Turning to the state.
Judge, we're 2 weeks out today from the preliminary hearing. Obviously, I haven't consulted with co-counsel on this, but I think we could have any objections that we may file. We haven't discussed this, but we could have those filed by Friday. If not, maybe Thursday. I'm not sure what the defense would do with respect to responding, but I think we could hear this prior to the preliminary hearing.
All right. Well, and I realize the position of both parties. I realize, Mr. Burt, we need to wait till the ruling of the court, and I realize, and I understand the state's response. Let's see what we can do to address that Friday. If briefing is completed, or if the defense needs time to respond to the state's briefing, whenever that comes in, the court will be sympathetic to that and will adjust accordingly. So tentatively, we'll plan on addressing that on the 26th at 8:30. But again, I respect and I want the parties to be able to fully respond. So we'll adjust to ensure that both sides have an equal opportunity to respond to this request, and the court will take it up and address it before the preliminary hearing as soon as you can. And the court will be flexible. If it can't be heard Friday, the court will find time to hear it the following week, well before the preliminary hearing, because I understand and I respect that you need time to prepare and make best use of your time. Mr. Burt, any thoughts?
No, Your Honor, thank you for that accommodation. I appreciate that.
All right. Any final matters before we conclude today?
No, Your Honor, not from the defense.
Not from the state.
All right. Thank you all.
Let's call it a day then.
So another hearing on Friday. The defense is planning to call witnesses. That's the first. I've never seen a preliminary. I'm sure it's happening, but I never seen one. Actually, watched one where defense called witnesses. So they really.
I have not seen a preliminary hearing last more than what, half an hour?
Yeah, it's something. It's usually like
some ridiculously short amount of time.
Like I said, the only preliminary hearing I saw that lasted that long was the O.J. Simpson thing. It lasted like 6 days or something. It went from June 30th, 94 till July 6th, 94. So
it's just, and hey, whoever, we're about to call it a day because we watched the end of the evidentiary hearing from a Friday, 2 Fridays ago. And then we watched the hearing from this morning, which was through Zoom or WebEx or however they do it. Well, we have another hearing on Friday.
Yeah. I'm just scared that this preliminary hearing is going to continue. They're going to try to drag this out and get this thing continued. And I hope this judge is like, nope, we're not continuing it. We're going to address it before this hearing starts.
That, just to read that order was like, I already ruled on the hearsay. You're wanting that witness to be here in person, subpoenaed, was based on the fact of he is a hearsay witness. I'm allowing hearsay, therefore he doesn't need to be here. Yeah. I'm like, one led into the other, and that could have been a whole. That could have been a lot shorter than it was.
I can imagine what the contempt what that order going to be. I know he's probably.
I think I took a nap. Trust me. I thought when Michael Burt was talking during that hearing, I honestly cannot remember a fucking word he said.
When or if we stream the preliminary hearing, y'all gonna need to have y'all snacks ready.
Oh my god. You need your emotional support, pitchforks, and a stiff drink. Oh.
Get a blanket.
I have seen trials that are shorter than this preliminary hearing is scheduled for.
That's why I said this really didn't need. They really trying to turn this into one of the biggest cases that ever occurred.
On that note, I do have to get going. Oh, I will see you Friday. We are going to be streaming. Well, I'm going to be streaming later that afternoon, like around 3:30 or 4. With that said, I will be replaying the hearing that afternoon because heaven forbid I watch one of these live. The last time I watched one of these hearings live, I was live for almost 6 hours. It's the longest live stream I've ever done in my career, and I don't want to do it.
Hearing, when they closed portions, I remember that hearing. They closed portions of it.
Yeah. We ended up watching sentencing in a different case. That Angel, can you turn it down, please? We ended up watching sentencing and different stuff, going through documents. It was, poof. But anyway, y'all, tomorrow might be a members only, depending on the day. We're having a delivery being made tomorrow afternoon. When I get a specific time, I will probably do a members only. No guarantees. Otherwise, we will be back on Wednesday. We have more aviation stuff to deal with and more documents to deal with in some other cases. We have to do updates on multiple other cases, including Anna Kepner. There was a major update in last week's the backdoor judge in Wisconsin. There was some shady shit that was going on up there. And then finally, she has been, there's some updates in that case that we have to get to. So Wednesday will be an update show. And then Friday will be partially what the hails, but will be partially going over this hearing. So I will probably have 2 streams set up and redirect to myself, if that makes sense.
It's been nice covering this case with you so far, because if I did this in court watch, I would have to do this thing live.
All right, y'all. I have to get going. Y'all have a great day.
Have a
and
great
thank
one,
you for hanging out with us, the 21 people that decided to hang out for this Shiza show.
We need to get 300 people in for these streams.
I'm not Emily D. Baker. I don't have the purple hair or the looks, but I lost 3 subscribers during this stream. So
wow.
It's all about, I don't know. And thank you to the 2 people who hit the dislike button. Appreciate you. Spoiler alert, the defense talks a lot.
It's my voice, y'all. They don't like my voice, so they like...
No, shush. They don't like Spawn. All right, but y'all have a great day, and I will see you guys on the next one. Bye. Try not to be a twat waffle. And baby girl, would you like to yeet us out of here? 3, 2, 1. I don't know if y'all heard that, but she said yeet.